Board of Zoning Appeals meeting to begin for its regularly scheduled meeting of May 18th, 2017. My name is John Michael. I work with the Metro Codes Department, and I'll be presenting the cases to the board for their review today. At this time, we would ask respectfully if you would please silence your phones, your tablets, any other devices you may have. Given that we have a number of cases to be heard today, we greatly appreciate your consideration on this point so that the board's proceedings will not be interrupted. With those proceedings, in each of today's public hearings, the board will have reviewed the correspondence submitted in support of and opposition to each of the cases. Additionally, the board reviews documentation from other government agencies that have reviewed the proposals, site plans, maps, photographs, and other pertinent data that makes up the case record. In each of these hearings today, the staff will present the site plans, maps, and other documents that comprise that case record for the board's consideration. At the conclusion of the staff presentation, the appellants will have the opportunity to come forward and make their desired presentation to the board. After the appellant's presentation, the board would then hear from any of those wishing to speak in support of the appeal being presented. Then, if the appeal has opposition, the board would hear from those parties who wish to speak in opposition. Once the opposition presents their testimony, the appellant will have the opportunity to come forward and present rebuttal testimony. Obviously, that's the plan for contested cases. Under BZA rules, an appellant has 10 minutes for the presentation if no opposition is present. For contested cases, both sides have 15 minutes to make the desired presentations. If the appellant wishes to provide rebuttal testimony, then he or she should allot some portion of that originally allocated 15 minutes. At the conclusion of each hearing, the board will deliberate on the case as presented and then vote on the case. The board is vested with the power to do so under the provisions of the Metro Zoning Code, specifically Section 17.40.180. All of the section numbers to which we refer today come from the Metropolitan Zoning Code, which applies to the entire jurisdiction of the metropolitan government. The Zoning Code was adopted by the Metro Council and put in place on January 1st of 1998. I will introduce the entire zoning code and make it part of today's record for each of the cases. The Metro Code requires a record of these proceedings. Because BZA meetings are recorded for the Metro Public Access Channel, it's imperative that anyone addressing the board come forward to address the board. Sit at the front table, use one of the microphones, introduce yourself by name and address, and then make the desired presentation. Because no sound will be picked up from the back of the room for the purposes of our recording, it is imperative that no one do so, as it will, number one, be an interruption of the board's proceedings, and number two, not be a recorded part of the record, which is what you want if you're going to speak at all. It's important for everyone to remember, if there are multiple people wishing to speak, whether in support of or opposition to a case, those 15 minutes are collective. You need to divvy up your time in advance to make sure that anybody you want to speak actually gets to speak. The Metro Code requires 4 members of our 7-member board in order to establish quorum. The code also requires at least 4 affirmative votes in order to grant an appeal. In the event that we have 5 or more members present and an appeal fails to receive 4 affirmative votes, then the case in question will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within that 30-day window shall be deemed denied by operation of law. Pursuant to board rules, an aggrieved party may appeal board decisions to the Chancery Court within 60 days of the original hearing date. Additionally, an aggrieved party may file a motion for rehearing within 60 days of the original hearing date, pursuant to the terms of the Board of Zoning Appeals rules and regulations. After that time elapses, the board's decision becomes final, and no further action can be taken. For the appellants, if your appeal is granted and you are seeking a permit, you must obtain the permit for which you applied. Board's approval will stay in place for only 2 years. After that 2-year window of time, if you have not picked up the permit, you're back to square one, applying all over again. It should also be noted that if any false or misleading testimony is presented to the board, any board approval could be revoked at a later date by means of a show cause hearing before the BZA. Mr. Chairman, I submit that the cases have all been filed in the proper order. All appellants have been notified by certified mail, and all legal notice requirements have been fulfilled. I think we had 2 preliminary announcements. Case 2017-098, not showing on the final docket but originally scheduled, is in fact a withdrawn case. Case number 2017-126, involving the property at 4100 Phil Hall Parkway, is being deferred to a later date. I know Councilmember Sam Coleman and a number of neighbors have been present for that case. Councilman, did you wish to address the board with that deferral? No. Very well. As the council member does not wish to address the board, that will be deferred administratively to a later date, a date to be identified once the community meeting obligation has been met. Those are the only two preliminary announcements. However, Mr. Chairman, we'd love to take this opportunity to recognize the elected officials who are present with us for today's board meeting. I've already acknowledged Councilman Sam Coleman from Antioch. And congratulations to the council member for his next upcoming role serving the metropolitan government. We appreciate you very much.
Yes, I would like to extend the congratulations to Councilman Sam Coleman, who has represented Southeast Davidson County very well and was just selected this past week to be the new General Sessions Court Judge. So we are very proud of your work. And thank you for your service.
Mr. Chairman, we also have present with us Councilmember Mike Freeman from District 16. Councilman, do I understand you wish to address the board until the case in question?
Correct, and on consent, no address.
Very well. Councilman will speak when his first case comes up, and also Councilmember from District 6, Councilman Brett Withers. Councilman Withers, do you wish to address the board?
I just have another one consent if it passes on consent.
Very well. With that, Mr. Chairman, we'll take the opportunity to announce with regard to our use of the consent agenda that one board member reviews the record for each case prior to today's hearings and identifies those cases where appellants met the criteria for their requested action. If the reviewing board member determines that testimony in the case would not alter the material facts at issue in that case, then the case is recommended for board's approval. We will enter into the record those cases that have been recommended. It's important that if anyone here stands in opposition to one of the cases recommended for consent agenda, please raise your hand so that we can know that you're in opposition, and the case will be heard in its regular order. The first case recommended on the consent agenda is 2017-036 involving the property at 402 South 11th Street in East Nashville. Is there anyone here in opposition to case number 36? Seeing none, the next case identified is number 2017-119 involving the property at 3196 Hamilton Church Road in Antioch. Is there anyone here in opposition to case number 119? Seeing none, the next case recommended is number 2017-120 involving the property at 3905 Burris Street. Is there any here in opposition to case number 120? Seeing none, the next case recommended for the consent agenda is 2017-128 involving the property at 505 Sarver Avenue in Madison. Is there anyone here in opposition to case number 128? Seeing none, the fifth and final case recommended for the consent agenda is 2017-129 involving the property at 2906 Foster Creighton Drive. Is there anyone here in opposition to case number 129? Seeing none, Mr. Chairman, that gives 5 cases for the board's consideration. We would solicit a board vote at this time.
Okay, can you repeat those cases again for the record and for the audience as well?
Sure. The cases for the recommended consent agenda are as follows. 2017-036 on South 11th Street. Case number 2017-119 at 3196 Hamilton Church Road. Case number 2017-120 at 3905 Burris Street. Case number 2017-128 at 505 Sarver Avenue. And case 2017-129 for the property at 2906 Foster Creighton Drive.
Okay, those cases are now moved to the consent agenda. Is there a second to the consent agenda?
I'll second it.
Okay, the motion's been made and properly seconded. Any discussion about any items on the consent agenda? Seeing none, all those in favor of the consent agenda signify by saying aye. Aye. Opposed? Passes unanimously.
With that, those whose cases have just been approved on the consent agenda are welcome to stay for the duration of the Board of Zoning Appeals meeting. They are welcome to leave if they wish. For the permits that you are seeking, give us at least until tomorrow so that we can enter the data into the system and help you get moving on your project. Thank you very much. With that, Mr. Chairman, absent any other announcements, we'll move on to the first case. Mr. Chairman, as you'll recall, case number 2017-116 involving the property at 949 and 951 Southside Place in Council District number 17 was presented at the last board meeting. That's an item A appeal challenging the height restrictions in the R6 zoning district for this two-family residential project. The board voted to defer this case to today's meeting for the purposes of gaining a little more information with regard to the subject property and the permitted construction that took place. The zoning map shown here demonstrates the proximity of the project to other R6 zone properties, and that, of course, is the 8th Avenue South corridor to the immediate east in this picture. The aerial gives you a layout, although a bit dated now, of the relatively dense residentially zoned area. The site plan submitted, actually two site plans submitted, one from the IA appellant and one from the builder, demonstrating accurately the measurements, one to the eave, one to the top of the structure, thus the crux of the question as to which is the appropriate method of measuring up to the 45-foot limitation. The aerial photograph here, the somewhat recent aerial photograph here, shows the subject property and structure in the lower left-hand corner, with the issue being the question of whether or not the parapet walls and the bulkhead for the stair are in fact to be calculated in the 45-foot required height limitation. From the somewhat recent site visit, view of the property from sidewalk, the view directly across the street, then the views up and down Southside Place along this block face. The item A appellant is represented by Mr. Dean. Obviously, there are folks still in opposition to the case, given that it is technically styled as a challenge to a previously issued building permit. Mr. Dean will have the opportunity to make the desired presentation to the board. Then his opponents will have the opportunity to present thereafter. Mr. Dean.
I wasn't sure whether, Bill, were you and John going to talk, or do you want me to just kind of trace it in?
We could hear from the zoning administrator. We have your letter, Mr. Herbert.
So y'all may remember that last meeting we deferred this one meeting so that I could go back and take a look at whatever documents that we may have. I've done that, and I think the board has got copies of the permit that was issued, as well as the site plans that were associated with that permit. In looking at it, the issue here is where you measure the height to. The face of the permit seems to pretty clearly indicate that the max height is 3 stories and the max height is at 45 feet. It says that it shall not exceed 3 stories to a maximum height of 45 feet. The maximum height shall be measured from either the natural grade. The natural grade is measured is the average elevation of the 4 most exterior corners of the structure to the highest point on the house. That was what was put on the face of the permit that was issued to the applicant, the builder, the developer. If you look at the site plans have where our zoning examiner, I think, very clearly denoted that the maximum height is 45 feet. You know, I guess it's my position that we, at the zoning staff level, applied the code exactly as the code was written, and to the extent that this structure was built higher than that, it exceeds the scope of the permit that was issued to it. So that's our position on it.
Okay, and before you start, Mr. Dean, I would make note that, as you know, we have a great Metro Nashville network, the network formerly known as Channel 3, and they have a YouTube channel. And so I went back and watched the correspondence of the last meeting on the YouTube channel. We used to be able, used to give us DVDs if we missed that particular hearing. So very high tech. They're on Facebook. Follow them. They do Facebook Live now. And
easier these days. When I first started, Mr. Chairman,
watch.
They used to have audio recordings, and before I'd file a case, I'd listen to those audio recordings. Yeah. Those were a mess.
But we are fortunate to have the Metro Nashville Network. These are public meetings. We encourage people to be here, and if you cannot be here, they are shown live on the Metro Nashville Network most of the time. and they're then archived. So those of you who are here today, they will be archived, these proceedings. So if you have a neighbor or friend that wanted to know what happened at this meeting, go look at their YouTube channel online, the Metro Nashville Network. Like I said, follow them on social media. We are pleased that they provide us the service to let our information out, and also our friends from our local TV networks, too. So, Mr. Dean.
And I'll be very brief, really. Everybody's seen most of you are here, and the chair has watched it on the tape. This really arises out of not the issuance of the permit, because at the time that the permit was issued, and I didn't realize this the last time I was here, that Richard Thermopoulos, who issued the permit, had actually struck through the height that was shown on that site plan and emphasized that it was supposed to be capped at 45 feet. My clients didn't realize this until sometime in the middle part of January, that there was a problem because the structure began to go above where it was supposed to be, they thought. I do want to just run through quickly, because there was some concern about the timing of the appeal at the last time, and I wanted to make sure that in case this had to go anyplace to the courthouse, we got our as-built drawing in round about the middle part of January of this year. I called Bill Herbert on January 27th, late that month, to say, we've got a dispute here, or at least I think we do. What do we do? Bill and I set up a meeting for February 1st. I met with him, had the as-built. Again, he's got a million things going on. I don't think he looked at the as-built that my client submitted at that particular time, but said, we need to get an as-built from the owner to see what the owner has to say about this. That meeting was February 1st. February 10th, I called Bill back and said, hey, have we heard anything from the owner? The owner had not at that point submitted the as-built. February 28th, actually Tom White and I were in Bill's office on a couple of other matters, and I brought this up again. The as-built had not yet been submitted. Actually went to see Byron Hall, who's the chief building code official, and asked Byron about that. While I was in his office, he made a phone call to say, hey, we need to get that in. It was evidently sent to Byron sometime around that date. I got a copy on March 2nd. On March 21st, I spoke with Bill again about which way was Bill leaning, and ultimately, I wasn't really sure how Bill was looking at it, whether they were over the height or not. So on March 30th, within 30 days of the date when we got the owner's as-built, I went ahead and filed the appeal. And the issue is not the building permit, because the building permit was issued appropriately. The real question is, did they go above the 45 feet, which is the maximum? And I think at this point, last time I was here saying that I thought that codes had an informal policy of allowing the bulkheads to go up above 45 feet and the parapet walls to go above 45 feet. I'm now kind of told that while that may have happened a couple of times, that most of the time that was not the case, that Richard Thermopoulos, my understanding is that he talked to Bill and said, Bill, no, a couple could get through, but no, if they come in and they show above 45 feet in the UZO, which is where this is located, we're gonna mark it and say you can't go up that high. Last time I submitted just a little Excel spreadsheet on the dimensions, and I'll just summarize and David Taylor talked about this last time. I went back and looked at some of the tape myself, and basically the bottom part of the property, both of the surveyors got approximately correct. The difference is like a quarter of a foot or something, 4 or 5 inches. It's the height that's different, and I'd submit to you that the reason is because the owner measured to the deck and didn't take into account the parapet, which goes above that, the parapet wall, and then the bulkhead, which goes above that. His height shows at 580, above the 537 grade, which is 42 feet, so would be under the 45 maximum permitted. Ours shows that to the top of the parapet, it's 46.89, so 2 feet over at the top of the parapet wall. And to the top of the bulkhead, it's 51.99, roughly 52 feet, so 7 feet over the maximum permitted by the code. I don't think there's too much doubt about that. The only other thing that I would want to draw to the attention of the board is that at the last meeting, I thought that the permit had been issued and there was not necessarily anything about the 45 feet on the permit itself. I haven't seen Bill's letter, but if he submitted that information to you, it's clear that Richard, when he looked at this, on the face of the permit itself, it mentions the max 45 feet, and on the site plans, the drawings, he's clearly crossed through the elements that exceed 45 feet and said you can't go above the maximum height that's 45 feet. What actually happened, and these things happened, the builder built it above 45 feet. The bulkhead is actually 7 feet above the maximum permitted, and the parapet wall itself is itself a couple of feet over the max permitted. We were appealing because it was my feeling that Bill looked at the two as-built drawings and said, well, I'm going to go right now with the owner's drawing. Truthfully, I'm not sure whether Bill actually made a final decision, but I felt like I had to appeal and get to the board. And so we're here asking the board to declare that the building's built in excess of the 45-foot maximum that's permitted, and to the extent that there's a zoning administrator decision to the contrary would be to reverse that decision. Has again nothing to do with the permit. Permit was issued correctly. Everything was done perfectly correctly at the time of the issuance of the permit. It was the fact that the construction went a little bit further than it was permitted to do. And finally, again, for the benefit of the folks who may not have watched the tape or anything, my clients are behind this property. They have built their property consistent with the 45-foot height restriction, and they can't sell it and say you've got a view of downtown Nashville with the extra 7 feet on the top. That's our problem. They are impacted by the fact that the building in front of them was built a little bit higher than what it should have been.
So can you, and I know you just said this, so I'm going to ask you to repeat it because I'm feeling a little dense about it. But it seems like between the last time we heard this and today, a couple of things have happened. One is that there's been a more thorough review of the case from the zoning staff, which basically said, you know, we issued permits and said 45 was the max height. There was no confusion. It seems very clear. And that's
right, and I accept part of the blame on that myself. I should have checked, and I.
Well, and that's fine. But then the appeal, though, is, I mean, we're you know, is, I guess, what are we? You know, you said that you'd like for us to acknowledge what both sides acknowledged last time was that, yeah, the other building's 47 feet. I mean, it's 7 feet higher than it's supposed to be, give or take a half foot, according to each side's measurements, which is trivial compared to the conclusion that, you know, it's either 7.5 or 8 feet over. You know, it doesn't matter. It's substantially over, and that 6 inches of difference doesn't matter. So I guess I'm just not sure what we're supposed to do if the codes did what they were supposed to do in issuing a permit, and both sides have testified here that the heights are there. What do we do?
Well, and really, to the extent that Bill Herbert believes that that's correct, then he can revoke the permit and ask that there's no action needed from the board to the extent that Bill takes that position. Bill, when he was talking before, was talking about that the permit was issued appropriately in the beginning, and there's no doubt about that. The question here had nothing to do with the original issuance. It has to do with the construction. And Bill had two papers in front of him, one showing it complied, one showing it didn't. Again, I didn't want to waste much time because, you know, it'd be unfair to the property owner. So I went ahead and filed. I didn't have a clear vision of where Bill was on that. If Bill believes that they're over, the board doesn't need to do anything. He can enforce the law, and the board doesn't need to take any action. If Bill believes that the owner built it consistent, then I'm asking the board to reverse him And really, I think both sides agreed, as you say last time, that it was over. So I don't really think that's debatable. It kind of turns on how Bill looks at this thing.
Well, I think it's undisputed that it's built over the 45 feet. So, and I'm going to say this, I agree with everything that Mr. Dean just said. I don't dispute any of that. And if the board remembers, at the last board meeting, that was the first time that I had actually put both site plans against each other and was able to compare them. What I didn't have at that time was what did we permit in terms of the height. I now have that information. So I agree with everything that Mr. Dean says, but just to clarify, Mr. Dean, I did not write anything. The only thing I did was get to the board copies of the permit for 949. I did not write an item,
opinion letter.
An opinion letter at all.
That's fine. That's no problem.
So I think it's built higher than we permitted.
Mr. Dean alluded to kind of how we used to do these things, and he characterized it as a rare occasion that we would sometimes let people do. How would you characterize in the past, what was our policy and where did it come from?
And that's part of what I had to figure out during the interim. And here's what I'm told by way of history, that there was a previous case many years ago in which a height variance was granted to allow stairwell bulkheads and parapet walls. It was my understanding that some of our zoning staff had continued to follow that forward and staying in agreement with that former Board of Zoning Appeals opinion. I was corrected on that during the week, and zoning staff has applied the law exactly as it's written in the zoning code, hence what we see in this application on this case. There were situations in the past under the former zoning administrator where people would come and ask for that type of variance, if you would. It's my understanding that some of those were granted in the past, but none by me. Going forward in this, it's my understanding that the building division may have not been applying when things were actually constructed. If a stairwell bulkhead was constructed, a parapet wall was actually there that was not allowed on the permit, sometimes they were allowed to go through. I don't know how many of those are out there. I have no indication of that.
So you're talking about the previous zoning administrator, Sonny West, who this room is named for. When you say people asked for a variance, would they ask this board for a variance or ask?
They would ask, it's my understanding they would ask Sonny. Okay. And Sonny, but based upon a previous board opinion, would sometimes allow those to happen. Now, I don't have any specific information on that other than what I've been told.
And his logic for letting it happen was, I know this is
well, so what I was told was that Sonny felt like everyone should have access to their rooftop. And you need a stairwell bulkhead to safely access your rooftop. And if you're going to access the rooftop, you need the parapet wall as a safety feature to keep people from just walking off the edge and falling. Okay. So that's how that came to be.
Okay. Mr. Dean.
Well, so Mr. Dean, I mean, so if we're in agreement on that, as far as the item A appeal goes, hasn't the argument been moot? I mean, do we still need to?
I'm glad to withdraw the appeal, provided that that's where Bill is, and you know, we would of course expect that it would be enforced. That was the problem in the beginning. Okay. It wasn't anything with Bill. It was my concern that we had the owner saying one thing, us saying something else, and didn't want to delay. I wanted to go ahead and file and get to the board.
Does the property have a use and occupancy or anything?
No, it does not. It's still in the course of construction, and it has not received its final inspections yet.
But the builder, who we haven't heard from today, would, no matter which way this case goes, would still have the option of appealing.
Yes, and the builder.
Appealable.
And the builder has made an application to this board for a height variance that'll be heard in June, I believe.
So it's already coming back to the board.
Any other questions of Mr. Herbert? Or?
So in essence, this case goes away.
And again, if the board would prefer with the pendency of the other case, I'm glad to withdraw our case because it would appear that there's nothing for the board to decide as to the item A.
Well, let's hear from the builder to see
Sure.
what they have to say. So,
No problem. Thank you.
please have a seat, press the button, identify yourself for the record, brief address.
Good afternoon, members. Adam Lefevre on behalf of the builder. Much of my argument was already taken care of in the discussion. It doesn't appear that there is an actual item A appeal here. Mr. Dean just acknowledged that the terms of the ordinance, 45-foot maximum height, comply with the terms of the permit that was issued, 45-foot maximum height. Issue here appears to be the fact that the building was constructed in excess of that 45 feet. As the board just noted, this appeal is somewhat moot. It appears it's going to be withdrawn, and the variance has been filed to be heard next month. Now, in way of Sonny West's old interpretation about the safety, there are a lot of these out there I can attest to, especially in this area. You're in a situation where you can't really see the bulkheads a lot of times from the ground, so nobody knows oftentimes that they're sticking up above the actual roof level. And if there's an aerial that shows neighboring properties, I don't know if you have one, there's an entire, I believe, somewhat subdivision being built around the corner that all has this design with the bulkhead. I haven't reviewed the designs of them to see if they're in excess of 45 feet, but the exact same design is being built.
I think that your client may have presented that picture last time, but I think that was an SP. So I think if you come back to make sure that the zoning is correct, but I think that the picture that we were shown that said, hey, here's a whole row of them, was actually an SP project that would have allowed for that.
The subdivision, yes, but these are dotted throughout the area, South Street, all those side streets over there. Appears to be the common scheme, architectural scheme that's being constructed over there just for the rooftop. And on another note, I know the board noted that the appellant is concerned because the bulkhead and the wall will allegedly block some of the view from his project. And I just, for way of clarification and candor, like to note to the board that the house that the appellant is constructing is advertised on the MLS as we will build a rooftop deck after the certificate of occupancy is issued. So in other words, it appears that the builder is going to get his certificate of occupancy at 45 feet, and then after the certificate of occupancy is issued, stick the rooftop deck on top. So it seems like the builders are doing the same thing here. It's just one is doing it before the issuance of the certificate of occupancy, and the other one plans on building the deck afterwards.
But for the purpose of this case, though, you are acknowledging that the building was built higher than 45 feet and that the permits were issued correctly, and that because you've applied for a variance, I mean, that's the acknowledgement that it's higher than 45 feet, or you wouldn't be applying for a height variance. You'd be looking for some kind of interpretive whatever. And so it sounds like that both sides of it have said, yeah, it's higher than 45 feet, the permit was issued, and therefore the item A is moved.
That's correct.
So do you have anything else to add before the next time you come here for the variance?
I think the parties are trying to work together to reach an agreement.
Okay, yeah, and we would encourage you all to meet in between our two meetings to see if you can come up with some resolution on this.
What's problematic, and I know the board isn't supposed to rely on precedent, but if a precedent is established, and again, no, the board's not supposed to rely on it, and you have the rooftop parapets, or the parapets, which are the railings, and the bulkheads, which is where the stairs come out, you're going to have kind of a checkerboard across the skyline of ones that were built prior to the board's precedent and ones that were built after.
Well, that may be the case, but what I was concerned about last time was whether you had relied on advice from zoning that may have been different than what we now believe is the interpretation of the law. But what I understand is you were permitted for a specific height, and we now agree that we've exceeded that height.
That appears to be the case, but we're here on the item A appeal that was filed, which is only filed stating that the zoning administrator erred in the issuance of the permit. So there cannot be an error if the permit was issued clearly within the regulations.
Any other questions? Do you have anything else to add? Okay, thank you.
My name's Harold Johnson.
Oh, yes.
914 Villa Place. I would like to also set the record straight. Last time when I came here, I have one individual that pulls all my permits for me down at the codes office. I thought that the permit had been pulled and granted at 51 feet. When she went down there and pulled the permit, I was not issued that document stating that Richard had marked through that and written 45 feet on there. Had no knowledge of that until I scheduled an appointment after we met with Bill Herbert and John Michael, and they brought the paperwork and said, whose signature is that? And I recognized it as one of my employees' signatures, so that was my error. Just wanted to clear that up, and that's all.
Thank you.
Thank you. So,
I want to say that things happen, and every problem usually has a solution. And I think the groups here are agreeable and working toward that solution.
yes, we have two parties represented by two very good lawyers. We hope that you all can communicate and come to some solution, but if you can't, that's why we're here.
That's hopefully the plan, at least the solution part of that statement is the plan.
Thank you. John Michael, so how should we now proceed given what has been said?
Very technically, the appellant has the ability to come back for a rebuttal period if Mr. Dean wishes to address the board with regard to whatever his intention may be at this juncture. It may make it easy for the board.
Let me make just 2 points first. One, my client does intend to add something to the top. It will be done with a permit and under 45 feet. He's not going to violate the 45 foot. They believe they can do that and still get a little bit higher.
Not come to this board
And not
asking
come to the board for a variance of any kind. And it wouldn't be necessary. They wouldn't believe that it was necessary to do that if this situation hadn't occurred. The other thing I wanted to mention was I did not appeal the issuance of the permit. Under Tennessee law, you can appeal any decision of the zoning administrator. Whether the height is the right height or not is a decision. Now, we didn't quite Bill didn't look at it until later. But again, I didn't want to wait. I just took that. And if you look at my application, it says to appeal the height of the building at 949 Southside Place. Well, it had nothing to do with the permit. Had only to do with the height of the building. Having said that, let me say that I'm glad to withdraw if that makes things easier for the board. I think at this point, it's kind of a moot issue. I think Bill has concluded that we were right in the first place, and so the appeal is...
John Michael, what's the cleanest thing to do for all parties, especially considering we're kind of hearing the variance next time?
If Mr. Dean wishes to formally withdraw the case, there's no board action required. That would conclude the matter, and as is acknowledged, this property be the subject of a variance case before the board, I believe, on the June 15 agenda at that point.
Then I'll just withdraw the case on behalf of my clients, and we'll likely be back for the variance.
Yes, and please get together and see if you can come up with
We're
something.
talking already, trying to find a solution.
We like compromise. Thank you.
Thank you.
Mr. Chairman, the next case to be presented to the board is number 2017-108. Ernest Alphen is the appellant and owner of the property located at 1507 McGavick Pike, requesting an item A appeal based upon a challenge to the zoning department's denial of a short-term rental permit. The permit was denied based upon prior operation by the owner of the property prior to receiving the legally required permit. Face of the property shown here from the tax assessor's website, and the aerial shows the residentially zoned neighborhood here. Mr. Alphen, if you'll come forward at this point to make your desired presentation to the board. You'll have,
here.
Is there anyone here in opposition? Seeing none, you'll have 10 minutes to make the desired presentation. Just introduce yourself by name and address if you would.
All right. My name is Ernest Clinton Alphen. I go by Clint. I moved into the area actually a year ago today from Spring Hill, and with the intention after buying the house to use the finished basement space as a short-term rental property, Airbnb. And I had been in the process of figuring out the permits and applying for the permits. As you know, there have been a lot of hearings and changes to the short-term rental property permit laws. And the first time that I brought my paperwork to the codes department, I thought that I had all my paperwork together and realized at the codes department they had a flyer passing out that the requirements to file the paperwork had been changed. around I believe it was the first week of February. There was a hearing, and so I left the codes department and mailed some more letters, did the required paperwork. During that time, I was also setting up my Airbnb profile, and was believing that I would have all the paperwork filed and everything in time. So I did accept a Airbnb request that they came and stayed and actually left a review on the on my site in the period of time where I was processing the paperwork. When I came back to the codes department, they viewed my Airbnb profile and saw the review and denied me the short-term rental property, short-term rental permit, and said that I could file an appeal or that I could wait a year, I believe it was. I filed the appeal, incurring the cost and mailing out the mailers for the hearing today, putting the sign on my yard, trying to do all this, as by the book as much as I can, and being new to the Davidson County area from Williamson County, it's a little bit of a challenge to keep up with the changing regulations with the short-term rental permit. Anyway, that said, I filed the appeal, and I have canceled any reservations that I had through Airbnb, and suspended my site on Airbnb now, so that no one can request to stay until the permits are in line. And so I'm requesting to be allowed to go ahead with my permit process, so that I can set up and be able to rent out my space, as it is an important stream of, or potential stream of income for me, moving into the area. And being a musician and former teacher, right now I'm in between steady jobs or day jobs. So I'm just requesting that I be allowed to continue with my permit, and with the understanding that I will not rent or accept any Airbnb request or put my Airbnb profile live again until all the permits are issued and in compliance.
Okay, so how did we get here? You basically didn't have a permit, but you started to rent Airbnb. Why did you start renting before you had a permit?
I was in the process of setting up the Airbnb and doing the permits at the same time, and I simply misjudged how quickly I was going to be able to get my permit, and the Airbnb people were asking me, why I haven't gotten my site live yet, and so it was a mistake. I stipulate that.
And this is your primary home?
This is my primary home. I'm not applying for a non-residence owned short-term rental permit. This is the house that I live in.
Okay. And you stopped renting as soon as you were told that you had to, as soon as you realized, hey, I really screwed up, I got to appeal, that's when you stopped renting, and you haven't rented since?
Yes, sir.
How many bookings did you cancel?
3, I believe, 3 or 4.
Okay.
Do I understand, even before you were doing Airbnb in the last year, you had not rented this property or this room or this basement?
I had not rented this basement.
Except
correct.
the one time you've discussed?
Except the one time that I've discussed.
And do you know a Miss Stipe? We received a letter or an email in opposition from her.
I don't know her, ma'am.
Okay. I want to show you this letter if I could. Could you step up, please?
Oh, yes, ma'am.
She had some complaints, and I'd like you to be able to just respond, if you would,
It's
please.
Sada Perry?
Nobody answered in opposition.
I think the person that wrote the... We also, and I'll read the very brief letter from Councilman Anthony Davis, BZA members. Currently, I've not heard from these constituents on any of these appeals. Both are being STRP permits. I'm currently not inclined to support anyone attempting to get a permit after they were operating illegally. Anthony Davis, Nashville Metro Council, District 7. Oh, please go back to the...
Yeah, we can take that.
Okay, so this letter is referring to a complaint that I had about my dog barking outside, and that the animal people came over and talked to me, and I assured them that I had made. They wanted to verify my dog's tags, which I showed them her vaccination record and her tags. And I also have since put a sonic dog bark suppressant outside of my house that has helped on her barking when I'm away. I wanted to do that short of getting a bark collar. Anyway, so I've taken measures to...
With regard to the coming and going of the vehicles, that was not related to the rental of this basement, is that right?
No, ma'am, it was not.
Okay,
Because
thank you.
as you testified, you've only rented it once.
The
and then
basement,
you
yes,
stopped.
yes, sir.
Okay.
I have a question about your dog. Are you aware that we have a prohibition in Nashville for leaving a dog on a chain? Is your dog chained, or do you?
No, ma'am, I have a fenced-in backyard.
Thank you.
Do you have anything else to add to your statement today?
No, sir.
And John Michael, can you see if we have anybody else that wants to testify in either support or opposition?
We'll check again. Was there anyone that wished to speak in opposition to the appeal?
Okay.
Please come forward, identify yourself by name and address
Please,
for the board.
Yeah, sit on the first row while the opposition comes forward. No.
No, you want me to?
Yes. Mhm.
Oh, sure.
Good afternoon. My name is Omid Yamini. I live at 1204 North 2nd Street in Nashville, Tennessee, 37207. I don't live anywhere near this gentleman. However, I am deeply enmeshed in the short-term rental issue here in Nashville. As evidenced by my T-shirt, you probably can tell my position.
Did you make that?
Excuse me?
Did you make that?
No, it was they sell them online. You can actually get a lot of them. Some are a little bit more offensive, so I don't
Well, thank you for not wearing an offensive shirt here, but we believe in the First Amendment here at the
Yes,
BZA.
thank you. Anyway, point that I'd like to raise is that, again, we are on the front lines trying to deal with this stuff. And we would greatly appreciate you supporting the policies that are in place and making sure that when people are found in violation, that they're held accountable for it and that these rules are upheld. Again, the councilman in this district has spoken about that in the email to you. I went and sat in last week at environmental court, and I'm trying to educate myself in this process so that I can see how all of this is working on all fronts. This is my first time to the BZA.
So let's get a little bit more specific to the case you just heard from the applicant. So
yes, sir.
Why are you against this item A appeal?
Well, he clearly stated that he knew of the rules. He knew he needed a permit. He had been applying for a permit, yet he chose to operate without a permit. I see that as pretty cut and dry.
So as someone that sounds like you're obviously against these kind of rentals, do you see any difference between someone like him that has rented once versus someone that is a frequent violator, or one of these non-owner occupied houses that have noise complaints and a bunch of other things?
Again, we could get into a lot of gray areas, but rules are in place for a reason, and he clearly knew of the rules and broke them. So to me, that's pretty cut and dry.
And I know you're new to the process, so originally the Metro Council passed an ordinance to regulate Airbnbs, and we were the kind of appellate arm before you go to court. and they just basically didn't give us any leeway that if you were in violation, we'd have to give someone a year punishment to be outside of Airbnb or nothing at all. The council recently relaxed that to give us some discretion, so we don't have to necessarily give someone a full year. So it sounds like what you're saying is you don't believe in any sort of discretion as it relates to this, and we should just always give out a year.
Again, you can use your discretion if you like, but if someone's coming before you and telling you that they broke the rules, then what should the discretion be? I mean, are we going to base it on, stories as to why they need the money? I mean, people can get roommates, right? The world existed before Airbnb. People were doing just fine. So, in my opinion, what was shared, there wasn't anything that would sway using discretion to sort of give leeway in this case. That's my personal perspective on it.
Okay. Any other questions for the opposition? Thank you for being here.
Thank you.
The applicant will have a rebuttal period. Come back. We'll ask you a few questions. So you heard from the general rebuttal, so you rented this once.
Yes, sir.
And then you pulled everything. So
Yes,
what
sir.
have you learned from this procedure and about the rules of Metro and kind of dealing with short-term rentals?
I have learned that I need to make sure that I get everything that I need to get everything. I need to be more careful about making sure my T's are crossed and my I's are dotted with the paperwork and everything like that. As the gentleman says, he doesn't live in my area and he doesn't know me. And I would just appeal to, as you said, your discretion to allow me to continue to go through with my process of applying for of obtaining the short-term rental permit for some time within the near future, less than a year.
Okay. Any questions of the applicant? No? Thank you for being here. We're going to close the public hearing. Discussion, board members.
I think in light of what we've heard today, this applicant has given us what we need to exercise our discretion. And while I respect the opposition, I also disagree that we don't have or shouldn't exercise discretion in this situation. He rented it once. He stopped immediately. It was a breaking of the rules, but he has refrained, it looks like, since March 27th from any rental. So I would move that he's able to apply a permit now.
I'll second that.
Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Passes 7-0 unanimously. John Michael.
The next case on the board's agenda is case number 2017-121. With an aerial photo of the zoning map shown here involving the property at 2901 Glencliff Road. This is an item A appeal challenging the issuance of the building permit number 2017-010925, specifically involving the use of the Glencliff Methodist Church in its proposed fashion. This is an RS10 zoning district. The aerial photo shows here the proximity of the church to East Thompson Lane, there slightly to the north and west in this photo, interstate out to the south and west. From the recent site visit, photos on the grounds, a beautiful day here at the church. On the upper left and lower left, the view up and down the streets, and the lower left going back toward East Thompson Lane, on the upper left going back into the residential neighborhood, and then the view across the street in the lower right-hand corner. Other photos onto the interior of the property shown here. Bring it back to the aerial shot. The appellant is actually the district council member, Mike Freeman. Councilman Freeman will, of course, not be restricted by the time constraints otherwise associated with speakers in our public hearings. Councilman Freeman will have the opportunity to address the board at the beginning, in the middle, at the end, and anywhere else in between of this public hearing, as should be the case for all of our council members. There are obviously opponents to the item A appeal as well. With that, we'll have 15 minutes for the parties to make the desired presentations. As I said at the beginning of the meeting, it's important for everyone to remember, that's 15 minutes total, not 15 minutes per person. Divvy up your time accordingly.
Councilman Freeman, welcome to the BZA. I appreciate you being here and giving your perspective on this issue. But before we get started, I would like to see by a show of hands who is in here in support of Councilman Freeman's item A part of this by raising their hands. Okay, that appears to be close to 40 people or so. And hands down, who is against what we just announced? Okay, looks like close to 20. So, Councilman Friedman, this is what being an elected official is about.
Yes.
And Mr. Chairman, before we begin, if I may, I believe I just told you that the challenge was to the issuance of the building permit. The building permit itself has not been issued yet, but instead the reasonable accommodation letter, which is what was issued by the zoning administrator some time back with regard to the planned building on this property. So that's what's subject to the item A appeal.
Okay. So before Councilman Friedman starts, tell us why this item A appeal is here and just give us a little background on this.
The short version is that typically from the outset of a use of a church or religious institution use on a subject property here, a residentially zoned property, if there is a use that requires review by the zoning administrator for the determination as to whether a reasonable accommodation is allowable under the terms of the Metro Zoning Code with an eye toward the state law, the Religious Freedom Restoration Act, and the federal law, the Religious Land Use and Institutionalized Persons Act, then the appellant would come forward, meet with the zoning administrator, or more aptly, submit the required documents laying out what their proposal is. The zoning administrator then has the opportunity to review, research the matter further, ask questions if need be, and once he's made the determination as to whether or not it's appropriate, issue a reasonable accommodation letter, either granting such or denying such. In this case, that accommodation was granted by the zoning administrator. I believe his letter is in your case packet. Granted, that's along with many other letters. But nevertheless, that's the one that we would probably draw your attention to here at the outset of the meeting.
And before we also get started, I'd like to ask our lawyer about the aforementioned Tennessee state law and federal law that relate to religious institutions. Tell us about these laws and how are they relevant to what we're hearing today?
The laws that Mr. Michael just referenced require there to be a reasonable accommodation for us not to substantially burden the religious exercise. There has to be a sincere, you have to find that whatever it is that they are trying to do is essential to their religious exercise or to their mission. So because this is if you determine that what is being asked, in this case, the building of tiny homes to provide transitional housing for homeless. If you find that that is, after you hear the case, not essential to the church's mission, then you could find that the zoning administrator acted in error or arbitrarily or illegally. If you find that it is essential to their church mission, in order to overturn the ruling, you must find that Metro has a compelling interest. So the government has to have a compelling interest.
So for those of, I had con law at Vanderbilt Law School, but for those of us that didn't have con law, tell us about a compelling interest standard.
Well, the courts have not given us clear, they haven't said, A, B, C, and D are compelling interests.
But in general, what is compelling? A high interest, middle interest, or
it is a high interest. There has to
like
be
a really high bar to cross.
Correct. In the two-prong, it has to be, you have to find that Metro has a compelling interest, which, as you said, is a high bar to cross. And you have to find that in not granting the reasonable accommodation, that it is the least restrictive means of furthering that interest. So you have to look at what Metro's interest is, as well as what are the means of achieving that interest. If there are least restrictive means, then you would look at that. If there are not, then
so ways to accommodate the same thing without granting what they're asking for potentially.
Correct.
Okay.
And so that we had heard a case not too long ago from neighbors that were opposed to a religious organization going on a particular street, mainly because neighbors had worked really hard to make that street a residential street. It had apparently a good view from the street, and I think Metro, the Planning Commission actually zoned that area especially to be residential, and the Metro Legal Counsel in that case gave us very strong advice to say that in itself is not a compelling interest, to say this, the desire to have certain things there wasn't a compelling interest, and really recommended. So when you talk about compelling interest, it really, I think it had told us then it really had to relate more to safety and that type of issue rather than just a desire to have a religious institution in a particular place.
that is correct. That was solid advice from Metro Legal.
I would, and we'll get to you soon, Mr. Councilman Freeman. Mr. Herbert, tell us about why this is a item A and your role in this.
I was approached at some point in December of 2016 by a group related to the church, and maybe it was even Open Table Nashville. I really don't recall who approached me about, they had evidently looked in the zoning code and seen that the zoning administrator has the duty to grant reasonable accommodations if in accordance with federal and state laws, specifically RLUIPA and the Fair Housing Act. So I told them at that time that I would need a letter detailing how this proposed use was essential to the church's religious mission. They provided me a letter dated December 30th of 2016.
I'm sorry to interrupt, but you said essential. That's a big word.
Yes.
So that's what you told them?
Yes, because that is the standard under RLUIPA.
So essential is almost, without it, you don't have an institution, right? Or how do you interpret essential?
Well, an essential part of the church's religious mission.
Okay.
I mean, I can't regurgitate specifically the language within the federal law, but
pretty high up, pretty what they're all about.
That's correct.
Okay.
So I asked the church to provide me a letter stating how it was essential to their religious mission, and I received a letter dated December 30th of 2016. They seemed to articulate why they would meet the criteria under RLUIPA. So based upon the information contained in that letter and that information alone, I issued a letter in response to the request for reasonable accommodation, and that letter was dated January 17th of 2017.
And for the many people that are here today, could you explain kind of how we're working today on this case and what an item A appeal is and what they were about to see here?
So an item A appeal is an appeal from any administrative decision from really me or the zoning department. It is set forth by state law and allows you to appeal any decision or the issuance of any permit. If you feel like that, if the decision to issue that permit or the decision, whatever we may have made, was in error.
So our job as a board today is to determine whether your decision was right or wrong. So we're either upholding your decision or overturning your decision. And now the council person, Councilman Freeman, he's the one that has brought this appeal, correct?
Correct.
Okay. And he has the right to bring this appeal, basically saying your decision was wrong, and that's why he's here today.
That's correct.
Okay. Thank you, Council.
I have a question
regarding
the fact that a permit has not been applied for. If a permit was to be applied for at some point, would it come back to us as a special exception case?
So a permit, there is an application for a permit, but the permit has not been issued and the zoning has not been signed off on. So typically, it's a special exception use for a church to locate within residentially zoned areas. This church is already there. I don't know that a special exception would come back to you. I can't answer that question right now. But what's before us today is an appeal of my decision to grant the reasonable accommodation requested pursuant to federal law.
And I understand, but when we do get the special exception cases, the board is allowed to put conditions on the permit. It doesn't seem that today we would be allowed to do anything of that sort.
I agree with that. I think it's simply, did I get it right or did I get it wrong? And again, I will say this, the only information that I had at that time on January 17th was the information contained within the letter, and I have to assume that the information that I'm being given is truthful and accurate in all regards.
Would you expect any other information? I mean, it seems pretty standard operating procedure to me, I guess is what I'm asking. Is
Generally, at that stage, I have no further information.
Okay. Before we get started with Councilman Freeman, again, let me remind everyone, each side has 15 minutes to speak. That's cumulative. So if the first person gets up here and speaks for 14 minutes, the next 20 people might have a minute left. Now, because we value the opinions of our elected officials and they're representing the district, Councilman Freeman has no clock on him. He could speak for 10 minutes, he could speak for an hour, and it's not accounting to anyone's time. I hope you don't speak for an hour.
No.
We're happy to have you. So with that, Councilman Freeman, welcome to the BZA. Please introduce yourself and your address.
Thank you, Chair. I'm Councilman Mike Freeman. I represent the 16th District, and obviously I represent both those for and against this project. And my appeal is not based on the merits of the project. It's based simply on whether Mr. Bill Herbert made his decision, or his decision was correct on the letter. When the letter was submitted to Bill Herbert, a phone call was made. I think we were talking, I think John Michael was on the phone, and I learned a lot about the RULIPA, the RIFA, and the other act in a short amount of time. And on the merits of that letter that they submitted, I had to agree with Bill's findings. But since that meeting, and since the community meetings we've had and the conversations I've had with Open Table Nashville, I've learned a lot more. This, it's only later, I'm going to have to catch up now, it's only later that we learned the church's role in this tiny home village. The church is simply a landowner. Here's what we know about the church side of the deal. Sewer connections are going to be provided for the church, and a new kitchen is going to be built for the church. So they are being paid for their land. In conversations with Open Table, I've also learned a lot more. She has stated this is an Open Table Nashville project. No members of the church will be day-to-day operations. She has also stated that they are in a contract with Open Table Nashville and another body, which I'll get to, that should the church decide to pull out of the deal, they will be sued, they will lose, and they'll lose their land. The project will go forward. And the last conversations we've had with Open Table Nashville, we find when pressed about the economic feasibility moving forward, I understand that the homes are supposed to be, it's a donation. We can sponsor a home. Each person could sponsor one home for a tone of about $30,000, I believe. Well, when you look past that, we have upkeep to maintain. We have, improvements that have to go on in this project. And in that conversation, we found out, it was stated that this is a Vanderbilt Hospital and St. Thomas Hospital project. They're the money. They have a coordinator between the two hospitals that will select patients to live in this village. There are 20 of these homes. Open Table Nashville gets to select 4. Glencliff United Methodist Church, 0. The hospitals have 16 homes. So this is a Vanderbilt and St. Thomas project. They have got with Open Table and convinced Open Table and the church by this RULIPA law that we can get this done, because these patients need a place to stay, and it's cheaper to build this village than maintain them in the hospitals. So again, this is not a church project. They are being compensated for their part. This is barely an Open Table Nashville project. As I told you, they get to select 4. This is the hospitals. The hospitals have the money, and they also have all the beds. And with that, I'll turn it over to the rest of the meeting.
Questions for the councilman before we'll obviously hear from you again if you want, but to start this, I have a question related to, you said that Vanderbilt and St. Thomas hospitals were involved in this, so how do you know that?
Open Table Nashville conversation. I was told directly that that's who was behind it.
And so your stance on this is that these homes, if not to sound like a law professor, but if the church just built these homes on their own without Open Table or any hospital or anyone else, would your opinion be different?
On the issuance of a letter, yes, it would be different, because this would be a church. The church is being paid. The church is a landowner in this situation. This is a landowner-tenant agreement that they've entered into.
Okay.
And I have a question about that agreement. You mentioned a contract. Is that the contract you're referring? Who are the parties to the contract?
I don't know, because it was disclosed to me in that same meeting that they were under an NDA, a non-disclosure agreement. So I have not seen them. I can only tell you that Open Table Nashville directly sat in front of me and told me those what I'm telling you today.
When did they say that, and who said that to you?
The first part about the sewer connections and the kitchen, that came out in a community meeting. You know, that was widely known knowledge. Then we had a subsequent community meeting that got a little heated because, I mean, people are passionate on both sides. You know, there are people who are passionate for this project and passionate against it. So I reached out to the director of Open Table Nashville. There was another councilman involved, and as well as a representative from the mayor's office. It was the four of us in this room. We were chit-chatting, and I kept pushing, what's the economic feasibility of this project? Because if we build it, say we spend $500,000 to build this project, where's the maintenance? What's the upkeep? And I just kept asking, and then finally it came out, well, this is Vanderbilt and St. Thomas.
Wait, so who's the we?
When you say,
well, you said we, where's the maintenance costs and all that come from? I mean, if it's the church property, whose business is it?
Well, I'm just curious as far as the neighbors. The church cannot afford.
But why is that anybody's business what the church can afford?
Well,
what does that have to do with anything?
What does that have to do with anything?
I mean, what other church finance?
Well, this is not church finance.
Can they afford to keep up their parking lot and their roof and their steeple and their lighting and their telephones?
This is a old church. It's an older church.
Should we kick them out?
No, I'm not saying that at all.
Well, Councilman, I think this is out of line. Well, whose business is the church finances?
This is not the church. This is not a church project.
It's a church property.
Just because it's church property, if I rent you my property, then I'm your landlord. That's secular. That's
so I
not
get to
religious.
know about your finances then?
That's secular, not religious.
Well, I think it's an interesting argument, but I do know that it's very common for religious organizations to partner with nonprofits of all types. And every organization that you mentioned that was, and I say supposedly part of it because and we'll hear from the others and they could acknowledge it. Now, we'll assume that that these are the partners involved. But they're all nonprofits themselves. And it seems like that, I guess, that an important part of that mission or important part of your argument would be how is their involvement not supportive of a church-stated mission in the letter of helping those less fortunate. If it takes going to Vanderbilt and St. Thomas and Open Table as partners to make that mission happen, how is that any less of the church's mission, and how does that all of a sudden become something that's not church-related?
I don't know if I can argue that point, other than the fact that the church is in a contract. They have leased their land. So it's a landowner-tenant agreement of some form. They may tell you, I don't know. I've not seen it because it's not been presented to me. These are just facts that they have told me. So I stand behind the fact that this is not the church is doing. This is outside organizations who are renting their space. And so that's what I can tell.
So that's the key piece. Okay, that makes sense. I understand.
Yeah.
Any other questions for Councilman Freeman? Okay. We're going to start the rest of the meeting, and we expect you to come back up and give us some updates or some opinions on what the other people say. Thank you.
Thank you.
So it's item A. We're going to hear from John Michael. Who should we hear from first?
The item A appellants are those who are basically on the same side as Councilman Freeman, having now already heard from staff.
Okay. So as you're reminded, this is 15 minutes that you have cumulatively. So this side will get 15 minutes. The other side will get 15 minutes as well. Please identify your name and address for the record.
May it please the board, I'm Marshall Albritton. I'm an attorney at Parker, Lawrence, Cantrell, and Smith here in Nashville, and I have been retained by several of the neighbors who are here today in support of Mr. Freeman's appeal. And I think that Mr. Freeman identified the issue, that there is a threshold question here. What's happened is the zoning administrator issued an accommodation based on a set of facts that were provided to him. And if those set of facts, that is for religious land use. It is not for secular land use. It is not for nonprofit land use by well-meaning intended people. It's specifically for religious land use. And I would direct, we have filed a letter in support of the appeal, and one of the exhibits to that letter is a letter from the pastor of the church to the congregation. And it says that this is an open table Nashville project, and to use part of Glen Cliff's property to build a micro village in collaboration with Vanderbilt and St. Thomas hospitals. So if Vanderbilt and St. Thomas Hospital came here today and said, we would like to use the religious land use exception, that wouldn't work. Vanderbilt's not a religious organization. It's not a religious. Serving the homeless is very worthwhile. We all support that. Methodism is a wonderful religion. My grandmother was a Methodist, and I've read their submittal, and there are many good things to say about the Methodist Church. But the religious land use law, both the federal and the state law, do not allow third parties to come in and cloak themselves with the religious exception. That's the issue that faces the board, and that's why I believe Mr. Herbert has stated, based on the information that he had, he issued the accommodation, and that is why the neighbors are opposed to it. It's these other interests that take it outside of a proper issuance of that accommodation.
Well, St. Thomas is a religiously-based hospital. Would they be allowed to use these same state laws and federal laws for?
I believe you would have to. I went online to try to find. There are a lot of St. Thomas organizations, and I could not find one to see if any were for-profit, if any were not-profit. There are lots of organizations that do have both for-profit and non-profit divisions, and I could not sort that out. But that should be sorted out.
Assuming that St. Thomas, the one that we know here, that's been here for 100 years, is not-for-profit and a religious organization, would they be allowed to have the same use?
I think we'd have to see the application. I think they would have. I think anybody that wants to use this law should come in and say, here's who I am. Here are my bylaws. This is a religious organization, and this is what we're doing. They should not be able to come in and say, oh, we're part of the church. And the church is religious, and the church believes in serving the homeless, so we would like for you to give an accommodation to the church. It's not about the church's finances, it's about whose project this is, and whether the church, there's a cloak that's being used and the law is being misused, even by well-meaning people. So the landowners have three basic problems here. That is that we've got a charter and a code and a general plan and a planning commission, the general plan having been adopted with 420 public meetings and 18,500 participants. With all that stakeholder involvement, the Municipal Planning Commission, the Metro Planning Commission, developed a land plan for the city of Nashville, and they developed a community plan for South Nashville. This project is not in accordance with that plan. And getting an accommodation because you're a religious organization means you can slip out from under that plan. And the neighbors are concerned because they believe...
But isn't that what the law says? Because you're a religious organization, you can...
Open Table's not a religious organization.
But this church is.
The church is, but whose project is it?
Okay.
Well, I guess the question is, how about, some of these mega churches that have Starbucks and, and 5 Boy Scout troops and all these other things that...
And they get taxed on it. There was a big case about Christ Church where they had to give up their gymnasium.
So are you saying that this is an acceptable project if they're taxed on it?
No, I'm saying that the religious land use law only applies if it's a religious land use. So that's all I'm saying. And you need to have, Mr. Herbert deserves to have, and you, good people, need to have all the facts. You cannot make a decision that's just in light of all the interest of all the stakeholders in this neighborhood, in this county, without the facts. That's what's happened, in my opinion.
Well, Mr. Albritton, let me ask you this, though. This is a land use issue, and we are dealing with a law that does affect our ability to regulate that land use.
That is correct.
And don't you think if the law intended there to be a difference between us being a landowner or us being a landlord, it would say so? I mean, because we're dealing with a high bar here.
You are, but and I would agree with everything you just said, but the test, if you look at the cases that I've cited in my letter, the test is whether it is a religious use. And the courts have said, for example, Calvary Christian Center, a 2011 case from Virginia, a religious organization had leased space for a private daycare school for disabled children. The court dismissed the RLUIPA claim because there were no facts demonstrating that the operation of the day school by a religious organization was a religious exercise. So there are cases that...
But let me, I want to really be on the same page with you, but this isn't a daycare.
This is
an issue regarding homelessness.
Correct.
And when I look through the paperwork that the church has filed, in all of their conference paperwork, everything, one of their issues that they discussed at every meeting is what about our mission on homelessness?
Right.
So this is different from a private daycare. This would be part of the church's mission. So tell me why it matters how the use is being performed on the property. Why does it matter, as you say, whose project it is?
Because that indicates whether it's a religious use or not. Both the use, well, for example, let's say that my church, Jack's Barbecue, came to my church and we want to feed the homeless. And Jack's Barbecue came and said, hey, I want to sell barbecue sandwiches out of your church. And we know you want to feed the homeless in Nashville. And we got a deal with Jack's. And then our church came down and saw Mr. Herbert and said, Mr. Herbert, we're not a restaurant, but we want an exception under the Religious Land Use Protection Act to sell barbecue sandwiches out of our church under the RLUIPA law, because we really care about the homeless and their ability to eat. And here are all our church documents that show you how much we care about homeless people and that people have good food. And Mr. Herbert said, we're going to grant that exception to the church. But then really the project is Jack's Barbecue, and Jack's Barbecue is selling those sandwiches, and Jack's Barbecue is the one that's running this thing. If you look at the cases decided under RLUIPA, and the language itself, there are distinctions. Another thing that in the Bethel World Outreach Ministries case from 2013 in Virginia, it clearly said, the court said, Congress did not intend to permit even religious organizations to exempt themselves from neutral zoning positions. So in addition to finding out whether it's actually religious use, you actually can go further. They're not exempt from all neutral zoning regulations. And so I started off my presentation by saying that the stakeholders in Metro and the Planning Commission that put together the community plan, that is a significant document, and there are things in there that Metro can still enforce. I think my time may be up, and are you keeping...
Well, you're not timed for questions.
While you're asking,
okay.
When we ask you questions, that does not go again, and you answer
I want to make
them.
sure I don't cut these good folks off.
So that's your clock over there, you're 11 minutes and 32 seconds. But when we ask you a question and you answer one of our questions, it doesn't account against your time.
So I'm is that about 3.5 minutes in?
Yes.
Okay, super, because I'm supposed to stop after 8.
So I appreciate your brief. and I'm curious if you could address, because we're not all lawyers up here.
Yes, sir.
I know it's hard to believe, but could you talk about if I'm hearing you correctly on the federal side of things, you're saying that since it's in your argument not a religious part of the religious organization's mission. I might not be using the right word, but we don't have to worry about that threshold of compelling interest. I don't want to put words in your mouth.
I mean, you do, but there's a threshold question before you get there.
Right.
You got to decide who's asking this and is this a religious use? And
exactly.
then once you settle those questions, then you're looking at the rubric of the statute.
So talk to us, if you could, and it might be a brief talk, but about the state law.
The state law has very little, we looked, and has very little guidance as to application in specific cases. It does use the term burden the church. It uses very similar language to the federal law, but we were unable to find any case law that discussed a situation like this. But the federal law has been around a bit longer. And the federal law has found, for example, I gave you that one case about a religious group running a daycare for disabled children. You can't get any more nonprofit than that. But they said that's not a religious use. Religion means you have a tenet, you have a belief system, you have doctrines, you have people who are in and who are out. Every nonprofit is not a religious nonprofit. And the law was designed, what was happening was that churches were getting discriminated against when they tried to build. That's basically what prompted the federal law and the state law. Neighbors would come to a meeting and try to shut down the development of a church. So they passed a law that would rein in planning commissions and boards of zoning appeals from being too harsh on churches due to neighborhood pressure. So that's why it was passed. But even with that, as I stated in the Bethel World Outreach case, the intent of the law was not to exempt churches or even religious uses from all neutral zoning provisions. And here, what's happening is because they've gotten this accommodation, they don't have to go through the planning commission. They don't have to subdivide. What if a developer came in here and had a deal with the church and wanted to get rents, but he said, hey, they're going to be below market? I mean, those are the issues. And the other thing that was said in the Aiden case, which is a Virginia case from just 2 years ago, this is the federal act, this act does not provide religious institutions with immunity from land use regulation, nor does it relieve religious institutions from applying for variances, special permits or exceptions, hardship approval, or other relief provisions in land use regulations where available without discrimination or unfair delay. And then in that case, the court held that what happened was you had a secular guy that owned the property, and he was going to lease it to the church. So the church came and made an application, or it may have been the owner application for approval, and the town denied a variance because it had a requirement in their zoning code that places of worship be 100 feet from adjacent residential properties. And the court held that did not constitute a substantial burden on religious exercise. So you have two questions here. One is this a religious use? And number two, does it therefore mean, even if you found that it was a religious use, which it is not in this case, does it mean that you therefore cannot impose any neutral zoning regulation? And the answer to that is flatly no. So the first thing these good neighbors would say is, let's find out, whose project is this? Let's see this agreement. Let's have Vanderbilt. Why would we disagree with asking Mr. Herbert to find out this additional information and then making an informed judgment about whether this really is a religious use, instead of making a decision based on a one-page letter from the church? I think that's a reasonable request. Then, if that were done, and this board found out, we think this is a religious use, we think Open Table is religious, and Vanderbilt's religious, and it's a religious use, then that still would not exempt them from going through reasonable planning and zoning steps. And no case is so held. So I'm almost 7 minutes in. I'm trying to think of other things that I can say that,
Well, I want to ask you a question.
yes, ma'am.
I want to pose this, what if? What if I were very wealthy and I'm a member of that church and I proposed to give the church the money that it would take to build and maintain these houses? Would you then believe that that was a religious use of that
Absolutely. Absolutely. There would be no question about that. Now, they wouldn't be exempt from all land use regulation. You'd still, I believe, this body and could weigh in on looking at their plans, but that would not be what we have here. I agree with you. Another case that was from First Presbyterian case, also a district court case, said when discussing a variance, it said when this church did not get permission to use a particular piece of land, they said that the denial of a zoning variance did not amount to a substantial burden. To begin with, the mere fact that the C1 zoning designation does not permit a church cannot support a substantial burden. Otherwise, every zoning ordinance that didn't permit churches everywhere would be a prima facie violation of RLUIPA. So really what this board is left with is, this may be the first case of its kind before you, but it's a precedent-setting case here. And I dream of driving down West End and looking at the Dominican property and seeing 1,000 micro homes on it, or going down Franklin Road and seeing First Presbyterian Church with 1,000 micro homes, or some other particular uses that maybe commercial people are trying to institute through the religious cloak of the church. So I'm 7 minutes in. The last thing I would say is, even if this board were to find that this is a religious use, and it is not, because Open Table is not a religious organization, Vanderbilt is not, based on the cases cited in our letter, and in particular, the really good information submitted by the Methodist Church, the bishop's letter makes it clear that this church and all Methodists in town can continue exercising their religion. There's a list of all the things they do for homeless people, supporting the Room in the Inn. They host overnight warming shelters and provide meals. They have bi-monthly overnight stays for the homeless. They have community care fellowship ministry, street outreach workers. This does not, the fact that you're saying they can't build a micro-village does not say they cannot minister to homeless people. It just means if they're going to get an exception under religious land use, it better be a religious use, and then they also don't get exempt from every possible planning and zoning standard. So I'm completed, and I will turn it over.
I have a question. I don't mean to step on my colleagues, but if I could ask one more question. Number one, when you say this is not a religious use,
Correct.
you're basing that on the person that owns the project, is that right?
It is part of it. The cases are not really clear.
Okay,
but when they say, for example, a daycare center for disabled children is...
Let me ask this. Do we disagree that serving the homeless is central to the mission of Glencliff Church?
I do not disagree with that, or the Methodist Church.
Okay. So it is central to their mission. And your concern then is because we have these other parties involved, it takes it out of the religious use. And so my question to you, and follow up to Ms. Sanford's good question, why do we not look at who the beneficiary of the project is? And in that scenario, the beneficiary remains the homeless, does it not?
Right, but where would we draw the line for commercial users using churches for profit? But how could this board then turn down my example where I came forward, Jack's Barbecue is in the background, and my church says the beneficiaries are going to be these homeless people that get really cheap sandwiches at my church, but it's a money-making operation for me and Jack's Barbecue.
Well, are you making a claim that these other organizations are going to make money and profit from this?
I do not know. Apparently what the councilman said was it was cheaper for Vanderbilt and St. Thomas to do this than to house them at their facilities. So they are making money. It's a money saver for them, sure.
Well, we have a lot of, I think we're going to have a lot of questions for the other side as well.
But I guess the example that you gave is if the barbecue joint only served the homeless, and only serve the homeless for $1 or whatever it is they charge.
Right.
Because that was something they did, then I think that absolutely is crucial. I think your argument only holds if all of a sudden you have non-homeless people. Well, they're not homeless if they live in a micro home, but people that weren't in a homeless situation that are being in this transitional living situation. If the other folks were living there and were paying rent and it was a for-profit venture, I guess I just don't understand.
Well, you're obviously analogies and details matter, but I was trying to come up with something that would perhaps resonate with you. And then the same thing would be true in analogies with regard to regulating uses. Could the church, if they believe in burying people, could they have a crematorium on their property if it was central to their mission to see that people are laid to rest appropriately?
I hope you don't consider this beating a dead horse, but I think it does get to the heart of the matter. If the church, Small C Church, Glencliff themselves, were saying, we want to do this program, and we are going to hire a company to manage it for us on our property. What then is...
It's the church's program. They're in total control of it.
So is it about who's paying for it?
The cases don't say that, but what it's about is the applicant being, you can have a secular applicant, but it's, so if the guy if I own a building and I want to lease it to a church, I can make the application under RLUIPA because the use is going to be clearly religious. The church is going to go in there, going to worship.
I'm not trying to be
But there is a connection. There is a nexus between the activity being done and who's doing it. If you don't recognize that nexus, then the board risks being really abused by any kinds of creative commercial enterprises that can find dying churches. Now here, we don't have that. Here we have the Methodist churches in the white hat. They're good people. But decisions have precedential value, and you're not always going to have that. And so the thing we would ask for is that the zoning administrator get all the facts before an accommodation is granted. You can't get a one-page deal saying we're the church and we're going to do this, and then you find out those aren't the facts.
I've got a question for staff. Is there a formal definition of religious use or religious institution in our zoning code?
There is, and I'll paraphrase it. It says, any structure that's used for religious purposes. Very helpful.
So Ms. Sanford asked you.
Yes, sir.
If she was wealthy and she wanted to give $1 million to the church, and they wanted to fund this thing, they would be able to do it. And I understand you say, yes, she could do that.
It would be a religious use. I know that they would have, I believe, a very strong case to get this accommodation. Now, I'm not conceding that they would therefore be exempt from any planning and zoning issues. That would be a separate question, but it would settle the question of whether it's a religious use in my mind, because I think there is a nexus. You have that nexus.
So that makes me wonder why. Where does the money come from? Does that matter? Apparently not. Apparently so. You're saying it does.
It does.
She's saying it does not.
Well, she asked a question. I don't know if she said that, and you could read it into it, I suppose. But I believe that that the law, the exception is there for religious uses, and non-religious people who, even if they're nonprofits, they've got to pay bills, they've got to pay salaries, they've got to do things, and they're doing good work that doesn't make it religious. Even if religious groups like it too, like I like raising healthy children, and I'm religious, but somebody may be atheistic and they like the same thing. If they do it, they don't get the exception under the religious land use law. That's just the way it's written.
Okay, who's next?
Thank you very much.
Yes.
Yes, thank you guys. We obviously there's a lot of anxiety in the room, and just thank you for hearing us. This is kind of our first public time for any of us to have a chance to speak. My name is Gavin Miller. I live at 261 Collier Avenue. I am the Glencliff, president of the Glencliff Neighborhood Association, which is just in earshot of where this church is. Most importantly, I have been involved in the church, in church leadership for my entire life. Both of my parents founded a church right outside of Washington, D.C., and we used this law to build a facility on our property to help our congregation. I can tell you that from the experience of going through that process, that the most important thing about the law is that it is directional. When you ask the question about where the money's coming from, if it's coming from someone in the church or part of that community, that would be the direction flowing from inside out, not from outside in and then back. So those considerations are extremely important when trying to figure out the intent of the project and who's running it. It's meant, the law is meant to be used by the church itself, not by outside third parties wanting to use the church ability to get an exemption to further their own projects. Open Table has had multiple public meetings with the community, yet not a single time has anyone from the actual church who was requesting the exemption been present. All of our attempts to contact the church have been redirected to members of Open Table. In fact, Open Table's frequently asked questions on their website, which they gave to the community, said, will the church financially benefit? If so, how? The answer was, there is no financial benefit to Glencliff United Methodist Church. Obviously, that's not true. There's the sewer systems and those things being added to the property. The second question was, what repercussions would the church experience if they did cancel their lease? The answer was, we would rely on our legal counsel to advise us to the legal repercussions. Those kind of statements don't indicate that this is a cohesive project between a church and its members. That shows that it is two separate groups trying to work a legal agreement out to run their project. When Mr. Harper, to address your question that was to the councilman about the finances, the original question and the importance of the finances came because we had absolute grave concerns about security on site and the funding that would be needed to provide adequate security. So our fear as the neighborhood was that the project would come about, they would initially pay for everything, which would be great, and then as those funds dried up, it would become less secure and it would become a liability for the neighbors in the community. So that's kind of why those questions were asked about financial feasibility. Not to say that we were just asking about their finances. I guess my biggest problem with this is that it is going to create a precedent. And it would be the first step in allowing third parties to come in and in this case, manipulate an elderly congregation into seeing things their way. And coming from a church background, I feel like it's a sacred duty to protect the trust that's been given to those churches to use those laws. And with that, I would just say thank you very much for hearing us. Any questions?
Any questions? Okay. Would you identify yourself with your address?
Yes, sir. My name is Jessica Van Dyke. I live at 2814 Hartford. I'm about a mile as the crow flies from this particular proposed development. I think that there are three main points that I want to make today, but the first thing that I would like this board to realize is that based on the information the community has, if Open Table Nashville did not exist, if Vanderbilt was not involved, if St. Thomas was not involved, the church could not do this program. Let's be very clear about that. This is a group of elderly parishioners who were put in a kind of a terrible position with the church that is growing in age, and its membership is as well. And the question for this board, and what I think you do have to look at, because if you don't ask the question, who's really doing this project? If you don't ask the question, why is this project happening? Who's funding the project? That means that any nonprofit can go to a church and say, hey, you've got a lot of land. I know you're falling on hard times, and we would really like to do something with it. Without Open Table Nashville, this project doesn't happen. Look at the packet that they provided to the board. The letters in it don't talk about Glencliff and being involved in Glencliff United Methodist Church. They talk about Open Table Nashville's a good group. They do a lot of good work. I've known them for years. Open Table's got this project. This is not a church project. The other thing that I want to point out is that neighbors had virtually no notice of what was going on. I myself, active in the neighborhood, did not find out about anything until March 3rd. March 3rd. We had a community meeting March 5th. And it was only after the community meeting that I then went online and looked up Mr. Herbert's letter. When I looked at the letter, I was astounded at the amount of information that was not included in the letter. This is a site that flash floods. They have poisonous snake signs out. This is a congregation that is dwindling in population. You know, there's other added layers here as well, which is what if the church administration, what if the big church wants it, but a little congregation doesn't? I think there's a lot of issues here. I think it does set a lot of precedents. What if the church, instead of building 23 microhomes, wanted to just make it a campground? And they were going to put 300 tents out there because it's their duty to make sure that everyone has a place to lay their head. Would that be okay? It's a religious use, correct? I think it sets dangerous precedent. Before my time is up, I do want to, if I'm able, I'd like to make this an exhibit. And as y'all know, we have a lot of people here that feel very strongly about this exact issue. We have over 145 different homeowners within a 2-mile radius that are opposed to this project, that believe it is not good land use and it violates our LUPA. And I'd like to make these, please note them. Many of them are unique signatures.
Okay, thank you.
And could I answer Ms. Chappell's question?
My unspoken question?
Well, it was a question. It was a question earlier about.
What was the question?
The question was about the daycare for the disabled children. And I agree with Mr. Albritton's answer. I only had one addition to that, which is that as you read the letter submitted to Mr. Herbert, and as you read any religious tenant, I'm sure for that church it was a tenet to help children and those less fortunate or less able, which is exactly what the Methodist Church is saying here. It's a broad tenet. I respectfully submit to this board that this would not impinge on their abilities to continue to practice their religion. Thank you.
Okay.
I would like to get zoning staff, either the administrator or the zoning chief, to address one of your comments, and that is that this project, in order to be fully permitted, will have to go through a codes review, and the buildings will have to meet health, safety, and welfare, and it will go to the stormwater department as well.
Yes,
Can you
that's
elaborate on that?
Yes, that's correct. So there'll have to be building permits for the structures that'll have to be inspected and fully code compliant in all respects.
I'm aware of that. Thank you, though.
Okay. Any other questions of any of the folks here?
I do sort of want to address something that you brought up. When you're talking about or maybe not you, but it's been presented that the church may have been taken advantage of, or maybe this church was in a poor situation, who would make that determination? I mean, how do we go about determining whether a particular church, if it is a church, and if our LUPA applies to it, is there some standard, and there may be that I don't know, that tells us which churches are able to make decisions and which aren't?
I think that's a great point. I think what was presented in the letter is not accurate, and I think you'll have to ask the attorneys for the church to elaborate on that. There's been information that's come out since then that there was a vote of about 25 individuals. There are people that are church members that I don't know how the process went about, and I can't elaborate on that because I wasn't there. But what I think does matter is who is not only voting on the project, who is implementing the project, who is funding the project, and who's ultimately responsible for the project. And I think that's a tricky question about how do we know if it's that's why I said it's multi-layered. What if the church administration wants the project, but the lesser church wouldn't? Would their church ideals be the precedent for an RLUPA decision? And I think that's up to the board. I think that's why the letter to Mr. Herbert is so important, because none of that information was included for him. He doesn't have any idea about, he just has a letter from the pastor and then one congregant.
Any other questions?
I do. I have one for Mr. Albritton.
Yes.
You didn't hit on this, but I see it in your letter, and it's about, it says the objection to the project and the zoning administrator's decision is not time barred. Can you elaborate on that for
That's
everyone?
correct. There's a section, obviously, in the code that says anybody who's aggrieved by the decision for a reasonable accommodation has 30 days. I believe the way that that's read, that it applies to people who are involved in that. These people, the letter, and the church did nothing wrong here, but the church sent a letter to Mr. Herbert. The neighbors have no idea about that letter. Mr. Herbert reviewed it. He made a decision on January 17th. He sent the letter on January 17th. Still, the neighbors have no idea what's happening. And if you apply that standard to them, then they have until February 17th to object. I think that the way that that section should be read, it should be an understanding that people who have notice and are involved in that. And as you heard the testimony here, none of these neighbors had notice until the 30 days had run. So that is how I feel about the objection. Is that sufficient? Or about the time bar? Thank you.
Okay, anything else?
I'm concerned that normally they would have rebuttal time, used up all their time.
It's item A, too. Yes. John Michael?
The board has the discretion to add more time if need be, or take as many questions as need be from the folks
so
presenting.
this is obviously a very important hearing, and I'm looking at the council person over there, too, who's brought a lot of people here and seen the time. So normally, as we stated at the beginning, each side gets 15 minutes. It is at our discretion that we can add additional time equally to both sides. Considering that I think there's a large number of people here, what do people think about this?
I think it's appropriate to add 5 minutes to each side.
Okay. So do I have a motion to add 5 minutes to both sides?
I'll move that we add 5 minutes to both sides.
I'll second.
Okay, motion's been made properly second. Any more discussion? Seeing none. All those in favor of adding 5 minutes to both sides, signify by saying aye. Aye. Opposed? So we're going to add 5 minutes. So what that gives you is you get to come back and talk after the other side does. Okay? And they get 5 more minutes too, so they'll have 20 minutes. So.
Thank you very much.
Thank you.
Let's hear from the other side. Please identify yourself and your address, and we can begin.
Good afternoon. My name is Lisa Carson.
Press the button. There we go.
All those years of higher education didn't serve me very well when it comes to the practical things. My name is Lisa Carson. I'm with the law firm of Berger, Mosley & Carson in Franklin, Tennessee, 306 Public Square in Franklin, Tennessee, and with me is Andrew Preston, who is an associate in my firm. I'm also the chancellor for the Tennessee Conference of the United Methodist Church, and chancellor is just a fancy word for essentially their general counsel. In that role, we are here today to represent the Glencliff United Methodist Church, the Tennessee Conference of the United Methodist Methodist Church and our resident bishop. And with us is Sandra Griggs, who is the pastor for Glencliff United Methodist Church. We also have with us today several members of Glencliff United Methodist Church, including the chair of its board of trustees, a representative from the bishop's office. The bishop is actually in Oslo currently at a meeting called the Connectional Table, and I'll explain that in a moment because I think it's important to this issue of whether this is a religious use. He sends his regrets, but as you all know, you have in your packets a letter from the bishop talking about how important this particular issue is to United Methodists in general, and certainly to our conference and to Glencliff United Methodist Church. The connection that I mentioned is important. The fact that we represent the conference, the bishop, and this church comes out of the fact that Methodism is a connectional church. And Mr. Albritton's argument, with all due respect, and I do have a great deal of respect for Mr. Albritton, overlooks the Methodist Church's emphasis on the connection. It overlooks the fact that Open Table is and has been a partner of United Methodist Churches essentially since Open Table Nashville's inception. And as you can see in your packet, it overlooks the fact that our Methodist conference every year, at annual conference, which is the meeting of our Tennessee conference organization, every year recognizes Open Table as one of its advanced specials. And what an advanced special is one of the organizations that we recognize as United Methodist furthers our mission. In fact, if you look at every advanced special resolution that we've put in your booklet, it talks about the fact that this annual conference is authorized by our Book of Discipline, which is our governing document, below the Bible, but above everything else in our doctrine. And it specifically says we're authorized to designate ministry projects within our boundaries that provide opportunities for our local churches to be partners in ministry. And every year, Open Table is one of those advanced specials because they are our partner in ministry. Mr. Albritton's argument overlooks the fact that Reverend Ingrid McIntyre, who is the executive director of Open Table, is a licensed local pastor of the United Methodist Church who was appointed to Open Table by our bishop. Open Table is not some barbecue joint that has come in to partner with us. It is an entity that is integral to our mission as the Tennessee Conference of the United Methodist Church and integral to the mission of Glencliff United Methodist Church. And there's never been any secret about Open Table's partnership in this. The church's letter to the zoning administrator led with, for years, Open Table Nashville in partnership with. And so it's always been known that Open Table was a partner. Everybody seems to acknowledge that if the church were funding this on its own, then it would be fine and it would clearly be protected. Everything a church does is funded by somebody else. Everything. And so it doesn't make sense to say that it would be fine for Vanderbilt and St. Thomas and Open Table to just hand over money to fund this project to fulfill the church's mission. But it's not fine for the churches to partner with people who have expertise to fulfill their mission. It just simply doesn't make sense. It cannot be that that is what's intended.
But this is a little different than that. This is a situation where the argument is the church, it's about the use of the land, not about partnering with other people. It's about partnering and using this land with our loop of benefits. I think that's the issue, or it is to me.
Right. I agree. And the church is entitled to those benefits because the church is using the land in conjunction with a partner through a lease that does not financially benefit the church in any direct fashion, although the church will receive, I believe, some grant money for its kitchen because its kitchen in the church will be integral to assisting in this project. But those partnerships don't change the fact that this is a religious use. Now, having said those things and having kind of asserted the privilege of seniority when I said I was going to get up here and say absolutely nothing, I'm now going to defer to my colleague who is younger and smarter than me and who knows the law in this area very well, and so he's going to tell you a little bit about that.
Ask you just a quick question, though. The opposition had talked about the Glencliff getting a sewer and a kitchen out of this, and you had just mentioned that the kitchen was essential, and I wanted to ask just what was the use of the kitchen. I saw the article in the paper yesterday that you all were coming here today, which I knew because I had the agenda.
Right.
But as part of that article, it had a little video of what the houses were going to look like. I said, well, I want to see what these houses look like. And they're very small. They're micro houses, and I didn't see a kitchen. And when they mentioned a kitchen, I thought, oh, well, maybe that's where the folks are going to eat. You know, there's a communal aspect to this or something. So can you tell me, it was presented as a price paid for the land by the opposition, but can you tell me a little bit more about why the sewer and the kitchen are important
Certainly. I'll be in big
components?
trouble because I promised our pastor I would try not to make her talk, but I'm going to make her talk because I think she's the best suited to speak to that with your permission.
Sandra Griggs, 2013 Priest Road, Nashville, Tennessee. Pastor of Glencliff and Woodbine United Methodist Churches. The kitchen thing, I think I'm the one who started that. I said anytime you do ministry in a church, you need a kitchen. We have a nice kitchen, but it has not been updated for a long time. We don't have a hood on our range. You know, it's the things of safety. Well, my example would be for this summer, we have a group of high school, I'm pretty sure, United Methodist youth coming to learn about inner city ministry. They need a place to eat while they're here learning about inner city ministry. Those are the kinds of things that we anticipate doing more of as we not just help house people, we help teach the next generation about caring for one another. That's pretty much it. And as far as the sewer, we are not on the sewer. So you can't do anything to the building unless you have a sewer. We're on septic.
I would like to ask you a question as it relates to this. So how did this all come about?
Well, Ingrid McIntyre and I are colleagues. I was serving on the board of ministry when she came through to become a licensed local pastor in the United Methodist Church. However, I probably knew her before then, so she's a colleague in ministry. When I started pastoring at Woodbine, I knew that Open Table was in need of a place to, they were growing as a nonprofit. So they had offices at Woodbine, our sister church. So of course I knew all about their ministry. People at both of my churches have helped with their ministry, have helped with their warming stations. We're presented things like this at annual conference, not only as to vote to support them financially. So, and also I was colleague with Ingrid's father, Dave McIntyre, and I know the ministry that her parents have both been in for a long time, and that's how we got to know each other.
But is this part of your mission? I mean, why are you doing?
Yes, it's a part of our mission. It's all about who the Methodist Church is. The world is considered our parish.
Why is this a priority?
Why is it a priority?
Yes.
Because it has been set by the cabinet, our bishop, and our conference, and everybody knows it's a growing need in the country to take care of. But it's always been a part of who the Methodist Church is. We were taught from our founder, John Wesley, in England, who really, some people believe, kept England from having the problems that they had in France. When France had the revolt, England didn't, because people went out and they started taking care of people. So it's part of our DNA.
So
it's
in the
who we are.
past, how did you deal with the homeless issue in Nashville?
In the past, churches I've been a part of have
But the
always
one that
done.
you're affiliated with right now.
Well, we pretty much have been into mercy and giving. We support by giving.
So you say mercy and giving, what does that
In
mean?
other words, instead of hands-on, most of the two churches I pastor right now do not provide like room in the inn, but every other church I've been a part of since I've lived in Nashville I've been part of room in the inn. We are part of community care. We go down and help feed there. So there's a lot.
In the past,
I have members that have to have.
So in the past, you go to like homeless missions.
Oh yes.
And feed people.
Yes, feed people.
If you just did that in the past, what kind of rose this to the level of we need to build some micro houses?
I think it started coming from my congregation. The first person that came to me said to me, we should do the little houses like they're doing at the Church of Christ. I think it's Green Street Church of Christ. And I remember just sort of tucking that in the back of my mind. Then the next person, months and months later, said, you know, maybe we ought to help do a homeless village. Like we knew that Open Table had this dream. So I waited till it started coming from within the congregation. And I have someone within my congregation who has housed a homeless person in her basement since I've lived there, since I've been there. I don't know how long he's lived there, but so, you know, it was part of the people that were there. They had already started taking care in their own ways. I have adults in our congregation who are caring for adult children that would be homeless if they didn't have them. So it's part of who we are.
We talked about kind of how all this comes about. Why couldn't you do this without Open Table?
We don't have that kind of financial resources. We are a collaborative church and a connectional church. And
what does a collaborative church mean?
Well, it means what you just talked about. You know, we're connected at all the levels. Like, I know a lot of the ministries that are going on at other Methodist churches within our annual conference and within our district. And we help each other. We support each other. We help if somebody needs money for something they're doing. For instance, one of the churches just down the street has started a food pantry. We give our food to Second Harvest, but we might start supporting them with the food pantry. So we connect. We're a church that connects.
So how's this all going to work? Who's going to build the houses and who's going to...
Okay, who's going to build the houses?
And who's going to decide who gets to stay in these houses?
Well, I don't know who decides who gets to stay in them, but I have had a conversation with my soon-to-be new district superintendent about how we are going to connect.
The church isn't going to decide to pick the people?
If I can speak to that.
Yes, you could probably speak to that.
One of the reasons for partnership with hospitals is that this housing is developed specifically for vulnerable individuals who are being discharged from the hospital and could be recovering under a bridge if they didn't have this type of transitional housing. So one of the things that will happen through the collaboration with the hospitals is they will, to my understanding, assist with selecting the individuals who are most in need and most appropriate. There are certain screening criteria that are non-negotiable. For example, anyone on the sex offender registry would not be eligible for this housing. But generally, we would rely on those. One of the reasons for the partnerships is so that we can have the expertise of Open Table, which has wide and deep experience in dealing with the homeless, and the expertise of medical professionals who know who is most in need.
So outside of feeding them and giving them a place to stay, you talked about medical professionals. Are they going to get any sort of ministry or help with medical help while they're in these houses?
Do you want to speak to that? I think that is part of it, and I think the specifics of that may be better addressed by one of our partners, Open Table. But the church's perspective is that there will be an opportunity for spiritual interaction with these individuals, which of course is
when will that
the
take
core of what
place?
we do while they're living on our campus, and we're actively participating in
So
church.
if someone's not interested in going to the church, or they're not that denomination or not Christian, what happens?
Well, everyone's welcome. That's not, well, I shouldn't say everyone, because not everyone.
Mm-hmm.
Those who meet the criteria.
Right.
We certainly won't be excluding people because they're not Methodist or even because they're not interested in participating in religion. But it gives us an opportunity. And that's one of the things that's great about Methodism, you know, that a lot of what we do in terms of our witness is through what we do and how we reach other people. It's not through going and preaching at people. And having these homes right on our campus of this very giving congregation, and it is small, and there are elderly folks in this congregation, but they have a heart for this project.
How big is your congregation right now? This one.
There's 1 minute. My secretary's in the back to ask her. I don't keep up with details.
Ballpark. Is it 500? Is it 200?
Oh, no, it's
69 members.
69
members. At the church conference, approximately 24 appeared to vote. And the church conference is the way in which the church, under the Methodist Book of Discipline, votes on significant issues, which would include a lease or a partnership of this nature. And 24 were at the church conference, and only 4 voted opposed to this project.
So are you leasing this land to Open Table?
It's a nonprofit lease, no money.
What is a nonprofit
I think it's a $1. I think we're supposed to get $1.
And how long is the term of the lease?
You would ask me that.
Well, I'm a little hesitant here because of some of the issues in the lease. There is a confidentiality provision around it, and so I don't know how much we should say about the specifics. I'm looking back at the folks from Open Table who are looking back at me and not giving me much help.
I guess that may be the question that, the opposition has raised is about the details of this agreement being important to determine how it is a religious use or not. And so I guess that was kind of the question on my mind, is how much of that agreement is truly necessary to satisfy, and maybe that's what you're going to speak about, because I know that you were going to talk more about the legal issues in a minute. But it does seem to be, those are kind of the questions in my mind, or just what are the details that might or might not confirm that this is a religious use, or prove their case that maybe it's not.
And let me ask the head of the church. So you say you're very familiar with Open Table, you partner with them. What's the need for confidentiality in a lease?
I don't know enough about that to speak to the confidentiality issue.
Well, that's the general counsel. So why have terms that aren't available to your congregation, the public, us?
I believe that the reason that the terms are not available to the public is because of the request of some of the medical partners. Yeah. And so that's not an Open Table thing, and it's not a church thing.
So the things that aren't available is the term of the lease, how long these properties are being leased for?
No, I don't think the term of the lease has any bearing on whether there's a religious use or not.
It could.
I don't know that there's a concern about revealing the term of the lease, so let me just look back here and ask. Yeah. Okay. They say there's not a problem with revealing it, but she needs to look it up, because I don't know the answer off the top of my head, and I apologize for that. I'm sorry?
So what's off limits to us then?
Sorry.
If I may address that, there is a boilerplate confidentiality agreement in the lease, but we have received permission from Open Table to discuss the terms of the lease.
Do you remember the length of?
I do not. I believe it's a self-renewing lease.
Okay. We got it. Okay, apparently we have permission.
Who prepared that lease, by the way?
I did not.
Can we ask the person that just handed it to you who prepared it?
Okay, the lawyers at Bradley Arent apparently prepared it.
And who do the lawyers at Bradley Arent represent?
Open Table, I presume?
No, the church.
Oh.
That's where the church's lease.
Oh, okay, it's a form lease. I apologize. It's a form lease that was prepared.
So Bradley Arent did not prepare it?
No, Bradley Arent did prepare it, but it's a form lease that they prepared for the church.
So who retained Bradley Arent?
The district, the Nashville district.
Okay, the Nashville district.
The Nashville district of what?
Yeah, and I apologize. I should
So
have known the
they
answer.
hired the law firm because technically they are the property owner in the larger scope of things,
Well,
being the denomination.
No. The Nashville district, this gets a little bit too much into how we over-organize in the Methodist Church, but each district has a district chancellor. And so on things that occur at local churches or at the district level, oftentimes I'm not involved as chancellor until later down the road, until there's a controversy oftentimes. And so the district chancellor, and it just didn't soak in with me when they mentioned that, but I suspect that the lease was generated at the request of the Nashville district superintendent, which is kind of the layer in the Methodist Church between the bishop and the local church. And
have you all read this lease?
Yes.
Okay.
Well, my associate has. I have not read it line for line.
Okay.
I've read it to determine the purposes, and the trustees have approved it. The trustees of the church have approved it. Okay. So the term of the lease, to go back to your original question, is for a 5-year term, and it's and then it can be renewed for 1-year terms automatically.
And you said it's $1?
It's $1 per year.
Okay. And what about the council person made some sort of mention if the church went under or whatever, that basically there would be this punitive part of the lease. Is that true?
I don't have any idea what that is about. The church's existence is not dependent on the lease.
The lawyer that read the lease. So talk to us about the punitive part if the church breaks the lease or isn't able to fulfill the terms of the lease.
I don't recall every provision from memory, but I do not recall reading any sort of punitive clause should the church break the lease. I know that the agreement runs.
Okay, well, let me ask the lawyer then. What are the material terms of this lease?
That Glencliff United Methodist Church allows Open Table Nashville to build tiny homes on their property and grants them a non-exclusive right at their sole expense to construct, install, and maintain these homes upon the premises in exchange for $1 per year.
So there are no clauses in that lease that would be considered punitive to the church if they weren't able to fulfill that or change their mind?
I do not recall anything to that. In fact, I certainly don't want to miss.
You've read this lease before, right?
I have. Okay. I did not notice anything like that.
There's an attorney's fee provision for breach of the lease, as there is in almost every standard
Well, that's pretty
lease.
standard, but like if you'd had to give up the church property.
Oh, certainly not. Absolutely not. That could not happen without approval of conference trustees, so I would be well aware of that if
So,
that.
to be clear, if the church is under no obligation, well, let me ask a different way. What if the church, I'm not sure what my Methodist parents are rolling right now, but should the church dissolve or not become a church anymore? I don't know what you guys call it, but what would happen then with the project?
In the event of dissolution of the church, you actually had it right. In the event of dissolution of the church, which we have no expectation is going to occur, that property is held in trust for the United Methodist Church. All Methodist property is held in trust for the United Methodist Church. So it would then come under control of the Tennessee Conference trustees. It would still be a Methodist property. And our Book of Discipline then lays out dictates for continuing to use that property in the furtherance of Methodist purposes and for the glory of God's kingdom. And the conference trustees would be in charge of making those decisions, and so they would become the lessor in that instance.
Thank you.
So it remains a Methodist property.
That group of people were the ones that hired Bradley Arent to come up with this lease.
The group of, no, the district office, which is immediately kind of, there's the annual conference, which is both an event, a gathering of people, and an organizational structure. The district conference, there are currently 7 districts in the Tennessee Conference. There will be 5 after our annual conference this year because we're reorganizing. The district level, the Nashville district superintendent, who is a person who connects directly to the bishop, would be the person who made the choice to ask the district chancellor to draft a lease for Glencliff United Methodist Church.
And they hired this law firm.
I believe this law firm is the district chancellor's law firm.
Okay.
I think, surely you could understand that the neighbors would have questions about these sort of relationships, whether or not they should be revealed. It does seem like there was some lack of transparency, and so I'd like for the lease to be made an exhibit to the proceeding so that people that want to view it are able to do so.
I don't have an objection to that if we have permission to do that.
We're under an NDA with 2 people that are in the lease, but if you want to wipe those names out, you can.
Would that be acceptable?
To redact what names?
There are two entities who are named in the lease that we do have a non-disclosure agreement with. May I redact those names?
Well, we're here to decide whether this is a religious use and who owns it and who runs it and who controls it. I think every name in that document that talks about building homes is relevant to our part of determining this case.
I mean, I tend to agree with Mr. Ewing fully.
I understand, and I want to say yes, and I'm sitting here just trying to make sure I don't breach a contract with someone else.
Well, we understand that your duty is to your people about not breaching a contract or getting disclosures, so you can disclose it to us. But we are in a position of trying to decide. You are asking us to do something under, these 2 federal law and state law that we need all the information as possible so we can make that determination, because we're having people in opposition, including the council person, saying this isn't a religious use.
I understand.
And I don't know that we've determined whether or not it's relevant, whether or not the parties to that contract are relevant, but they may be. I mean, I would say for purposes of this hearing, I think we can ask it to be made an exhibit and then determine whether the names would be redacted.
Sure. Let's ask our lawyer about these kind of things. So we're asking for something, knowing that there is a potential non-disclosure on the other side. Is there a good way for us to proceed with that document?
I cannot give any legal advice with respect to a contract between parties that Metro does not have any privity to. So, I mean, if there is a binding contract that Metro's not a party to that contract, I can't give any legal advice with respect to whether or not that should be.
The only two parties to this
breached.
contract are Open Table Nashville and the trustees of Glencliff United Methodist Church. On behalf of Glencliff,
So is there a
I'm
reason?
going to go ahead and submit it as an exhibit.
Okay.
So could they sell these homes? They develop them and sell them? That's what I want.
Ask the question.
So
Could you sell these homes?
I'm sorry?
Could the developers of these homes sell them out?
No. The lease is a lease of Glencliff's property, and it's for purposes of, the lease expressly states that it's for purposes of building a community for people experiencing homelessness.
And who's going to own these homes?
Who will own the homes?
Yeah, what you're building.
The buildings will be owned, I believe, by Open Table.
Open Table will own the buildings and all the fixtures contained therein. The
There's
property
actually a
will,
provision in the lease for removal of the homes under certain circumstances, and that the church property would have to be restored appropriately.
And let me ask this, because I did hear you did indicate that Open Table Nashville was to construct, install, and maintain.
That's correct.
And I don't know this particular parcel of property, but is it limited to a portion of the property? Or does this lease mean that Open Table Nashville can put these wherever they deem is appropriate?
if you look to tab B of the packet that we provided, there is a concept plan that demonstrates where these houses will be placed.
I saw the concept plan, but are they restricted under the lease? Does the lease restrict the property at all? Are they leasing this entire parcel of property?
No, they are not. The church will continue to operate, and I believe the lease contains a provision that deals with not
So
interfering
the lease talks about not infringing on the other, okay.
Why didn't you pursue a zoning change that might just allow these homes to be built like an RM zone change?
The Metropolitan Code sets forth a procedure for parties who are seeking a reasonable accommodation to protect their rights under RLUPA or RFRA, and this is the procedure specifically set forth in the Metropolitan Code. The zoning administrator is to make a determination and grant or deny that reasonable accommodation. So this is the avenue that the Metropolitan Code sets forth for us to pursue this type of accommodation.
But people go through zoning changes all the time to try to increase density on their properties. You probably could have gone through that zone change or applied.
This is the specific procedure set forth by the Metropolitan Code for this type of accommodation.
So the opposition had made a point that RLUPA doesn't apply and gave several examples of why it doesn't apply. Could you tell us specifically why it does apply?
Absolutely. If we want to just discuss the legal standards initially, I think Counsel for Metro did a fantastic job of explaining the protections and the standards under RLUPA. I did want to clarify one thing. The essential to standard is not actually the standard under RLUPA. Under RLUPA, religious exercise is defined as any exercise of religion, whether or not compelled by or central to a system of belief. And it also includes the use, building, or conversion of real property for the purposes of religious exercise. This is an example of Glencliff United Methodist Church embracing a religious call that is core to their doctrine, the call to serve the needy, the call to love their neighbor as themselves, and finding a practical application for that by partnering with Open Table Nashville, which has the resources and the infrastructure to allow the congregation at Glencliff to engage in this kind of ministry. It's a clear exercise of their religious beliefs, and it's an impressive and commendable practical exercise of those beliefs as set forth in the gospel, as set forth in the Methodist Book of Discipline, There's a specific resolution in the Methodist Book of Resolutions on homelessness, which calls on Methodists to use all their power to eliminate the causes of homelessness and to work along with others to eradicate it. By partnering with Open Table, they are working with others to eradicate homelessness by providing shelter to those who are most vulnerable and most at risk of dying on the streets. The fact that this is an exercise of their religious beliefs seems incredibly clear. We've provided a lot of documentation in support of that at every level of the Methodist Church, from the top down. The congregation at Glencliff clearly believes this to be an exercise of their religious beliefs. They voted overwhelmingly in support of this project.
But, sir, I don't think Mr. Albritton even opposes, I mean, we agree that providing for the homeless is central to the mission of the church. His question is, it's different if it involves this business relationship with the church and another party.
Absolutely.
And then we've got this specter of hospitals, and the church really doesn't have any control over control over the use. So how do you say that it is a religious use?
Let me first address the specter of hospitals. I think that's a great way to phrase it. This project is designed to help those most vulnerable. And so as part of that, local hospitals will be referring people who are being discharged so that they have a safe and supportive place to recuperate from their surgeries or their injuries rather than having to recuperate under an overpass. That is the involvement of the hospitals as I understand it. As far as the partnership with Open Table goes, that does not diminish that this is an exercise of Glencliff United Methodist Church's religious beliefs. As I just stated, the definition of exercise is very broad, includes the conversion of real property. Also, the Open Table itself is a faith-based organization. It is an interfaith organization, so it's not specifically denominational, but as Ms. Carson addressed, Reverend McIntyre, who heads up Open Table, was appointed to that position by the local bishop for the United Methodist Church.
But here's the struggle of many. If the church has the lease with Open Table Nashville, but Open Table Nashville has an agreement with other parties of which we are not aware, how do we know that the homeless are being served? How do we know it's not college students? How do we know it's not somebody else? So you're asking us to sort of just believe that because that's Open Table Nashville's mission, and I don't disagree with it, but for purposes of making this determination, how do we do that?
Well, for one thing, this reasonable accommodation that was granted by the zoning administrator is specifically to build transitional housing for homeless individuals. So I would think that if Open Table was using those homes in a different way, we might have recourse before y'all to pursue that if they're not respecting that reasonable accommodation.
But we don't have any way of knowing who Open Table Nashville is or who is being sent to Open Table Nashville. We as the board, the church doesn't know. Again, I'm not questioning the mission really, but it does seem to me those are reasonable questions about how the housing is allotted, as opposed to the church saying to the community, we have 22 homes, and every month we get together and decide which 22 people are going to have a home, or how that's going to work. The church will not have any control over that. While I agree that the homeless are still the beneficiary, I want to understand how we ensure that it's a religious purpose.
And the system for selecting people to inhabit these homes, as it's been explained to us, is that it will be a combination of individuals discharged from hospitals, and it will be people who have a very high score on the vulnerability index, which is a set of criteria used by Open Table Nashville and other similar nonprofits to determine who are at most risk out on the streets. So those are the criteria for selection as they've been explained to us, and those certainly fit with our mission of serving those in need.
Then let me ask you this, and I'm sorry, I know I'm asking a lot of questions. For purposes of qualifying under our LUPA, how many levels can you go through and still qualify under our LUPA? We have the church to Open Table Nashville to some other vendor or group. How far can that go? How far does that protection have to extend?
I think that the protection certainly extends to Glencliff in their pursuit of this, and that the fact that they have partner organizations doesn't change that. They are the property owner, and they have determined that they wish to use their property in this fashion. The fact that they have enlisted third parties does not alter that. At least two of the cases cited in the brief that we provided you all involve churches that were working with partner organizations. West Presbyterian was working with a local nonprofit, and Stewart Circle was actually at least three churches that had formed a collective to engage in this kind of ministry to the homeless. So in these, federal courts have recognized that the presence of a nonprofit partner does not impact whether or not our LUPA's protections extend to this kind of ministry.
And keep in mind also, there will be oversight of this project. We're not talking about a tent city. We are committed to and are required to, under the reasonable accommodation, to build code compliant with our partner. And we as the property owner are held to that standard.
So I have a question. So you build 20 houses, 30 houses, whatever, and someone needs to go to the grocery store, someone needs to go to the hospital. Is there a bus line near here? How are they going to get around?
There are provisions with the healthcare partners as well as others in the community for transportation for some of these individuals. There is transportation provided for TennCare patients for medical treatment.
So what if I need to go to Kroger?
There's a Kroger very close to the property. There's actually a Kroger right on the other side of the interstate.
So they have to cross the interstate?
Well, I'm sorry?
So how?
They don't have to cross the interstate? Okay.
So how many minutes would it take me to get to the Kroger if not having to cross a interstate part of traffic?
Without my phone up here to MapQuest it, I could not tell you the answer to that.
Have you made that walk before from the church property?
I bet you could make it 20.
You haven't?
20 minutes.
I bet you could.
I want to ask the council person that. Come over here.
There is a bus.
As far as where the church is located to relation to the Kroger, I know this because I've actually requested from the mayor's office a sidewalk to link them. And the sidewalk measures about 1.5 miles, of which I believe the church is about halfway. So it would be, under 1 mile. So the average person, whatever they walk. There is also a new bus line that just came on board in the last month, I think is what it is. So that's the relation to the church.
I mean, the reason I'm asking these questions, they're living on your property. I'm assuming no one has a car, so how are they just going to get around and just be citizens of Nashville? I'm not talking about health care. If they want to go somewhere, how do they get there?
Well, part of Open Table's partnership with us in maintaining this community will be to assist in coordinating that transportation. Open Table has a bus. Medical providers who will assist will also provide transportation.
Do they have a bus for non-medical related transportation?
Yes, there are occasions when they transport for other reasons.
But if I wanted to go somewhere twice a week or 3 times a week, would Open Table take me to wherever I wanted to go?
I can't answer that specific question. It would probably be dependent upon where you wanted to go. But with due respect, that really doesn't have any bearing on whether this is a religious function that is entitled to a reasonable accommodation.
I'm interested in kind of how this works and who's controlling it and why this is set up this way.
Well, we make no bones about the fact that Thanks, Ingrid. That Open Table, as our partner, will be handling those logistics. The reason we partnered with them is because that's what they're equipped to do. And so I'll defer to Ms. McIntyre, or to Reverend McIntyre, excuse me, Ingrid.
I'm Reverend McIntyre, and I also live in the 16th District and am less than a mile away from this property. We will have a care coordinator that will be on staff at the Microhome Village. They will be on staff, and their job is to get people into permanent supportive housing. Since our inception, actually this week, 7 years ago, after the flood with the residents of Tent City, we've housed over 650 people in permanent supportive housing. Our retention rate is at the highest level of any national standard, which is 85%. So there will be someone on staff as well as a nurse on staff to work with folks specifically to get get into permanent affordable housing. So this is a place where of respite, where people can become healthy, who are at the highest risk of dying on the street, since there's a 14,000 person waiting list to get into public housing right now, and only 49% of our Section 8 vouchers are actually being utilized in Nashville. It has become a more lengthy waiting period for people to be able to get into permanent housing. So this is a place for them to be able to stay so that they don't die on the streets.
And the care coordinator, do they work in the daytime? Is someone available at night if someone needs help?
Yeah, it's they're 40 hours a week, so it'll be during the daytime. Our offices are actually also at Glencliff United Methodist Church, so people will be in and out of there, but just like any other resident of the neighborhood, they will have emergency services available to them. Part of the plan has 2 emergency, like, I don't know what you call them, like emergency poles, like on campuses, that if people, in case people don't have access to phones, that they can call an emergency, whatever, responder, whenever they need. It's, yeah. I mean,
So you already have offices at the church right now?
For a year we have, because we, like Reverend Griggs said, we were at Woodbine United Methodist Church and grew a little bit, and there was a little more space at Glencliff United Methodist Church.
I'm sorry, who has the offices?
Open Table.
Open Table Nashville has
So
offices
Open
at the
Table
church.
is already on this campus,
Yes, sir.
on this property.
Yes, sir. I mean, I'm an appointment to the United Methodist Church by our bishop, so it's like, I mean, they mentioned that earlier. So hence a lot of our relationships.
Could you explain to us I know that it was explained for you, but I'd like to hear from you what your relationship is to the United Methodist Church and what Open Table's relationship is to the United Methodist Church and how that relationship has been in existence.
Yeah, so for 4 years, I'm a local pastor in the United Methodist Church, and after many struggles, because I'm a little bit unconventional, but with the permission of our bishop, was appointed to Open Table Nashville instead of to a pulpit, which I did not feel like was my calling. I did feel like it was my calling to serve people on the streets, to serve people who have been marginalized, which we like to do, as Sandra said, a lot of mercy ministries, but it's oftentimes more difficult to do justice ministries, which means actually stopping cycles of poverty, making sure people find permanent supportive housing. And so since I was appointed, we have been, actually before I was appointed, Open Table Nashville has been an advanced special of the United Methodist Church, which means we receive funding from them. Is that helpful?
So there is a long-standing.
And I'm a PK, so that means I've been in it forever.
So is Open Table a religious affiliation?
Our statement is that we're a nonprofit interfaith community that disrupts cycles of poverty, journeys with the marginalized, and provides education on issues of homelessness.
And as interfaith, what does that mean in terms of, you have a religious aspect to your...
We do. The reason it's interfaith is because sometimes a lot of our friends on the streets don't feel welcome in places because of their religious beliefs that might be different than other places. And we wanted to make sure that everyone felt like they had a place at the table, which is why we're called Open Table, because we want everyone to be cared for and loved no matter where they are in their journey.
So how long will the average person stay in one of these houses before they're transitioned to permanent housing, as you said?
That's a great question, and if we could all put a lot of pressure on our city to build more affordable housing, it would be less. Right now, from the time we work with meet someone that we are working with, until they get into permanent housing, it could be anywhere from 3 months to 2 years. It just depends on what the situation is. It took us 2 years one time to get a veteran's birth certificate from Guantanamo Bay, Cuba. Usually it's not that long. So usually between like 6 months to a year, just because of the housing market.
Are you responsible for selecting any of the 20 people to go in these houses? And if not, why?
Yeah, I definitely will be.
Will you pick all of them?
I will be looking at all of the applications, absolutely, because I
Will it
know
be
and we
your
know.
exclusive decision to take whoever you put in the houses?
No, we'll get referrals from our partner communities, and then the care coordinator obviously will have an option in that, as well as the nurse who will be on staff. But I will absolutely be looking at all of the folks that they recommend.
I guess let me ask it a certain way. Do your partner communities basically have a certain amount of houses they could just put people in regardless of what you have to say?
No, they do not.
Do they have any?
No, we've definitely set a standard that we're the ones.
So if you don't want someone for some reason, or you want someone else besides this other
Yes.
person in your triage system of determining who's most beneficial to be in your houses, you can basically tell your partners, this is how it's going to work.
In terms of the hospitals, because we know we have a lot of experience in working with people in community, and so we can tell after an interview or so, like who is going to work best within a community that we're forming, and who won't. And so that's the reason why, basically, because we have experience working with folks who are experiencing homelessness.
So the hospitals are making a referral.
Correct.
And suggesting, hey, we think this person is a fit for your program. And then you decide yes or no?
Correct. So just for an example, 93 people were memorialized this past year in 2016 for dying on the streets. Half of those people were on waiting lists for housing. Half of those people were on waiting lists for housing. So this is a bridge to be able to say to the most vulnerable of those people, we care about you. We want you to be able to live.
Well, that being said, if the hospital is about to discharge someone and then there's just somebody that's living on the street downtown, would you basically tell the hospital person that's getting discharged, no, I want this person downtown over the hospital, or basically whoever the hospital sends, do you take?
No, that'll be, they're referrals. So we will be able to look through those and see.
Most of the time accept their referrals. That's
No, we have 4 outreach workers that work in each of the quadrants, and people don't come in to see us. We are out in encampments and jails and hospitals and wherever that we meet our folks. And our outreach workers would die if they didn't have places to be able to put people that they're working with who are just as vulnerable. So we will definitely have spaces for people who are, say, living downtown.
So how much does each one of these houses cost to build?
Around $30,000.
And who's paying for that?
We accept no government funding for this project. So 40% of our funding comes from faith communities, and about 25% comes from individuals, and the rest of it comes from foundations, private foundations and grants.
So do you have the money to build 20 houses right now?
We have sold 20 houses, yep.
You've sold them. What does that mean?
Well, sponsored. People have sponsored 20 houses.
Okay.
Several of them being faith communities, several of them being in honor or in memory of loved ones, et cetera.
Who pays utilities?
We will, Open Table Nashville will pay the utilities for those houses.
So did Glencliff Church come to you all, or did you all go to them?
I would say, like Sandra said, that it was sort of a bubbling up, that because we were in the space and we had been talking about it, and we eat lunch with them a lot of times on Thursday afternoons when their members eat lunch together at the church, that questions started happening and conversations started happening. It was sort of like Open Table Nashville itself. We did not mean to happen, but we saw some terrible things that were happening and loved the people they were happening to. And so it was very grassroots.
Reverend McIntyre, thank you so much on behalf of the needy people that you help, because the people that you help, it benefits all of us as a community, and that's so appreciated. I want to make sure I understand how the house, I didn't quite understand your answer to Mr. Ewing's question. There is some medical component. The intent is that people that are getting discharged from the hospital will have bridge housing. That's
Correct.
how I understand it.
Yes, ma'am.
Is there any other flow from which applicants will come, or is it strictly from hospital discharge?
So 2/3 of them will be from hospital discharge, and 1/3 of them will be from our own outreach workers who are working with people who are high on the National Vulnerability Index.
All right. Are those hard numbers when you say 2/3, 1/3? Is there some written agreement, or?
That is still being configured with our partners.
But even if it's 2/3, 1/3, of those 2/3, if you've deemed someone to be inappropriate for the community, you do have the right to say no.
Absolutely. I mean, so I'm the worst. So either of our partner hospitals could say to us, like, here's a list of 10 people, and our outreach workers could say, oh, we know 3 of them. This person that we know probably won't work in community very well, but these other people do. So let's take these 2 folks because I think that they'll be really responsive in this community. And these, again, I want to say, just to dispel any questions that we have gone to our hospital community partners. They did not come to us because we already work with them on the street with like street psychiatry teams and other folks that they see come in their hospitals all the time, multiple times a week sometimes. And this is a way for us to be able to work with people to divert them into permanent housing instead of just continuing to decay on the streets, really.
So is there a any kind of direct financial benefit to the discharging facilities? I mean, essentially.
Well, because they would be discharged. They will not discharge people who should not be discharged because they actually care about their patients. However, like most of the people that get discharged would then, of course, go live in their encampment or go sleep by the river or wherever it is that they're sleeping. And then what would happen is they would probably get an infection or break something else or whatever it is, and then they'd bounce completely back into the hospital.
But let me ask you, what I'm sort of getting at is there's been this, it's sort of been suggested that there's some idea that there's a nefarious connection between the discharge and going to the Open Table Nashville new micro village. Is that the case, or how did this come to be? How did you partner with the hospitals?
So we've already been partnering with both of them for 3 years. One, like way before this ever even came up, we've been partnering with them. One of them provides mental health care to us when we cannot provide someone with mental health care or maybe prescribe them the meds that they need. And so we call a particular doctor and they come out and do street psychiatry because this person wouldn't necessarily come into a hospital, but they would meet someone in their own. So we've had that relationship. So sort of through conversations together is how this is bubbled. Again, very grassroots. It was like, how can we serve our friends the best, right? How can we serve them the best? That's what we care about.
Any other questions?
Yeah, I just wanted to clarify something about the church organization. So can Glencliff Church at any point say, we don't like this, we want to shut it down for whatever reason? Do they have a mechanism to do that?
So in the lease, do you still have it?
Unfortunately.
Where's the lease? Okay.
So you may have to go from memory.
Okay, so what I do know is what we agreed to in the lease is that if for whatever reason this doesn't work or we aren't following through with the things that we said we have followed through with, that we have a set aside amount of money that will return the property to exactly what it probably not exactly, because there's a tennis court there right now, but that we would return it to what it looked like before we built.
And if the congregation, the local Glencliff congregation decides they don't want to do it, can the I want to say session, but that's not right.
The annual conference.
The conference can they mandate that the church do it?
No.
Do the program? Can the bishop tell the church to do it?
No.
No.
So from 5 at night till 8 morning and whenever your office opens, who's looking out for these folks?
They're actually going to be in safe houses that have locks on their doors, which is a lot more than what they have when they're sleeping outside underneath a tent. They will be super safe. Well, I will say a lot safer
But
than...
if they have a medical issue or some sort of issue, who's there to make sure that they're taken care of?
The emergency services that they would have if they were living out underneath the streets. We will also have security that will be driving through during the night, just to check on the folks, check on each other. But this is a community, and people take care of each other in community, which is what we're trying to build, and which we also know is far more successful than people sleeping outdoors.
Oh, I get that, but if there's a medical issue that happens overnight that maybe shouldn't require hospitalization or going to the ER, is there someone around that is just around that can just take care of someone overnight?
Like their mom? I mean, I'm not sure if I understand.
Things happen.
They do.
Off hours. And so it sounds like either the security guard, who is probably just there to make sure that everything is quiet there, or the local emergency room is their only option.
Yeah, the local emergency room is usually their only option because they don't have health insurance. And so when they need health care, that's what they call all the time anyway. And there's there's a study that shows that people who are living in housing where they are safe and have air conditioning, they do have kitchens. I heard somebody ask about that, and restrooms. They are going to be far less likely to call for any sort of emergency services, obviously, than if they were out on the streets.
And this is not intended to be a skilled nursing facility. I mean, it's intended to serve people who are able to be discharged from a facility. So just like if I have a medical emergency in my home and my husband happens not to be home, I'm going to have to call 911.
But as you said, these are often some of the most fragile people because you have triaged them to take care of the people that you said 50 people or 100 people died on the street last
93.
year. 93. So these are people that could happen to them if they weren't here.
Could. And I'll be real thankful that they were in a house and not out by the bridge somewhere, because we have found dead.
But given that this is such a fragile part of the population, what extra are you doing outside of just putting them in the house at night and locking the door and hoping nothing happens to them?
Well, because we have a care coordinator that is working with each of them to set up their doctor's appointments to make sure
at night. What happens at night?
Yeah. They can call the emergency room. I mean, just like Lisa said, like I would do, I live alone as well, and I don't have health insurance, so I would probably do the same thing.
Other questions? Okay, you still have 10 minutes, so you could either continue to speak or other people on your behalf who agree with.
I think Andrew has a lot of great information.
I think to address some of the other portions of the legal standards, I think we've covered the religious exercise portion pretty exhaustively, although I'd be happy to take any more questions on that. The other portions of that protection offered by our LUPA is that any restriction that creates a substantial burden on the exercise has to be in service of a compelling interest under federal law, and under state law actually has to be essential to a compelling governmental interest. The burden that a prohibition on this kind of service would create is a substantial burden, and in the 3 cases that we've cited, that was found. In particular, in Harbor Missionary Church Corp., the court found that zoning regulation that would prohibit the church from conducting their homeless mission on their property and would either require them to cease that or to relocate, that created a substantial burden. I think it's fairly clear that a denial of this reasonable accommodation would create a substantial burden. We've heard a lot from community members today and prior to these meetings, prior to this hearing at our meetings. There are understandable concerns, absolutely. the house next door for me put up a for sale sign this weekend, and I certainly want to know who's going to be moving in next door. Having said that, we have reached out, and Open Table has reached out. There have been 3 open meetings to address the concerns of the neighborhood. There has been a community council proposed by Open Table, which would feature 2 representatives from each of the 4 adjacent neighborhoods. As of yet, no one has signed up for this council, but that will be a body that will allow Open Table and Glencliff United Methodist Church to address concerns from the neighborhood. And Reverend McIntyre has spent 60-plus hours meeting with individuals in the community to discuss these concerns. Having said that, and working with the community is very important to us as the church and to Open Table, we are dealing with rights that are guaranteed by the Constitution and by federal and state law. And I can think of multiple examples from U.S. history where the exercise of people's civil rights, be they religious or otherwise, have caused discomfort in the community. We want to minimize that discomfort, but these are still protected rights under the statute. The statute applies to Glencliff's partnership with Open Table, to the exercise of their religious calling to serve those most in need. And for those reasons, the zoning administrator was absolutely correct in his determination that Glencliff United Methodist Church, as the property owner, was entitled to a reasonable accommodation.
Okay, so I've had requests to take a 5 to 10 minute break, so we are going to come back. You have 7 minutes and 15 seconds, so we've been going since 1, so we're going to take a short break, and then we'll be back in 5 or 10 minutes.
Mr. Chairman, we'll gavel back into session with a continuation of case number 2017-121 involving the property at 2901 Glencliff. We respectfully ask that anyone choosing to remain in the audience, please take your seats and come to a quiet order so that the board can continue with its hearing. Mr. Chairman.
So we are going to resume. We have 7 minutes and 15 seconds left, and the floor is yours. This is your time, so please state your case.
In answer to one of the questions that was asked prior to the break about where these homes would be located and what input the church had on that, I believe that the lease that I handed up did not have the exhibits, if I recall correctly, and Exhibit B to the lease actually shows the area where the improvements may be constructed, and it specifically provides that it will be in a mutually agreeable location. So if I could pass that up.
Sure.
Now I will defer to Mr. Preston.
So as we're discussing the test under RLUIPA and the even higher test under Tennessee's RFRA, just any prohibition on building this project or prohibiting the church from exercising their religion in this way would be a substantial burden on the exercise of their religion. This congregation has voted and chosen to engage in this ministry as an exercise of their religious beliefs. So under those statutes, a substantial burden on that would be impermissible. Clearly, a prohibition would be a substantial burden. A delay would be a substantial burden, and also this is an incredibly time-sensitive project. Winter will be here before we know it, and that is when the individuals who this seeks to serve and who Glencliff seeks to serve via this project are at the greatest risk of passing away on the streets. The size and the age of the congregation have been raised. RFRA and RLUIPA do not apply equally to small churches, mega churches, young churches, older churches. This is a statutory, and it's a statutory right that essentially codifies the First Amendment's right to free exercise of religion. There is also no compelling governmental interest that's been identified so far that prohibiting this project would serve. In fact, the metropolitan government has clearly articulated an interest in providing housing to the population that this project will serve, from everything ranging from the establishment of Metropolitan Homelessness Commission or Commission on Homelessness to frequent statements made in the press by our current mayor regarding the need to address the homelessness crisis and to provide safe and secure housing for these individuals. as the tests under ARLUPA and RFRA cannot be met, I don't think that there is no reason to prohibit or to delay this project. The zoning administrator's decision that a reasonable accommodation was required in order to enforce the protections offered by those statutes was correct, and we ask that this board not disturb it.
If you would, educate me a little more about compelling interest. Do you really think the government has no compelling interest in regulating the safety or the enjoyment of property of the other property owners in this community?
If I may speak to that, I think that I've represented government for 25 years, so usually I'm advising somebody who's sitting up on one of these types of boards. And I think that the government clearly has a compelling interest in security and safety of both the individuals who will be housed here and the individuals in the community. However, there has been no indication that there's no evidence in the record whatsoever that these individuals create a higher risk to the community. There's no evidence in the record whatsoever that the building of these types of homes on this portion of the church's property will decrease property values. In fact, the few studies that have been done are that they tend to be either value neutral or sometimes even result in increases in value in the neighborhood. Because candidly, people living in safe housing rather than under underpasses and on the street are less of a threat to property value. And so while the government has a general compelling interest, there is no specific compelling interest in stopping this particular project. The compelling, if we were talking about putting a hazardous waste dump on the church property, then obviously there would be a compelling government interest in protecting the safety of those individuals. If we were planning to bring individuals from prisons, maximum security prisons, and instead let them just kind of have a camp out there on our church property with no security, that would be something that I would certainly expect this board to be very concerned about. But there is nothing in the record before this board that would suggest that these homes create a higher level of threat. And frankly, the Department of Justice guidance on ARLUPA would suggest that merely economic concerns, even if there were evidence of those, would not be generally sufficient to support a compelling governmental interest to interfere with the free exercise of this congregation's religious beliefs.
Any other questions? Do you have anything else to add?
I do not, and I don't believe any of the other folks who are here in support have chosen to speak today.
Yeah, if someone else wants to come forward to speak on behalf of this group, this is the time now. If not, we will hear from the council person.
We would simply ask, and I know that many of the I apologize.
Would you like to speak?
Yeah, can I speak from here?
No, you need to come forward and sit at the mic so the folks at Metro Nashville Network can hear you and our court reporter can document you.
Hey, my name is Lindsay Cranks.
Oh, press the button, please. Thank you.
My name is Lindsay Cranks, and I'm a minister, I'm a chaplain, and I'm one of the co-founders of Open Table Nashville. I've worked with a lot of churches. One of the ways we get a lot of our support is through working with churches and partnering with churches. Nonprofits are able to create an expertise in a way that churches can't when churches are serving their congregation. So we're really excited about this partnership with Glencliff because it kind of fits both of the gaps that we have. As a nonprofit, we don't have the land, and as a church, they don't have the expertise to fulfill this. One of the reasons that we started Open Table Nashville was because a lot of us were driven by our faith to provide housing for people without housing, and it's been a dream of ours to do a tiny home village like this since the flood at Tent City, since 2010. We have always partnered with churches. We formed Open Table as a religious nonprofit because we're so deeply invested. We have, out of our co-founders, I want to just speak to the religious part of Open Table for a minute so you can understand that we're not a Jack's Barbecue for a second with a couple more minutes. when we founded Open Table, 4 of the 5 co-founders are ministers. We have 2 ordained ministers on our staff, 1 deacon from the Methodist Church, and 2 chaplains. We partner with street chaplaincy programs. So we're really excited about this process. We have a lot of expertise in this area, and I hope that you'll find that we should be granted this appeal. A lot of our faith demands that we provide for those who aren't. And if you look around the city of Nashville right now, Mr. Young, one of the questions you asked is, what has changed? Why does Glencliff need to be doing this right now? When you look at what's going on in the city right now, our affordable housing crisis is huge. We're losing our friends on the streets. I'm doing a memorial this week, another memorial this week for our friends on the streets, because there's not enough housing. So when you ask why the moment is now for something like this, it's because our people are dying, and this is an issue of justice. Our religion demands that we do mercy and walk justly, and that's one of the things we think that we're living out in this. So I just wanted to speak from one of the co-founders' positions on this to the religious issue at hand, and I really appreciate your consideration of our side of things.
Okay.
So thank you.
Any other questions?
I have a comment. I appreciate all your comments, and thank you for all that you do. Somebody mentioned, and it may have been the other side, that there was other transitional housing in Nashville. Are you aware of that?
One of the things we've seen over the last 4 years in Nashville and on a national and local level is that transitional housing is being defunded by the federal government in favor of more permanent housing. So in Nashville, we've actually lost transitional housing beds over the last several years, which creates an even bigger gap. So when people are trying to apply for permanent housing, there's not a lot of transitional options because that's been defunded. Park Center, an incredible mental health nonprofit, has lost funding for some of those beds. So we really feel like we're filling a gap that that's not being filled right now, and we're pointing people toward permanent housing. Like I mentioned, our people are dying on the streets. This is a dire need for our community, and our religion compels us to do this work beside of Glencliff.
But your organization still is not a religious institution in and of itself.
We are, when we filed our paperwork to be a nonprofit, we incorporated as a religious nonprofit, and we decided to be an interfaith nonprofit, just like Room in the Inn. The mission, the men's and women's mission, is a faith-based nonprofit, but they're Christian. Room in the Inn and Open Table are both interfaith religious nonprofits.
But my question is, you alone, as Open Table Nashville, would not qualify for the legal statutory protection that we're talking about.
That would be a question for the legal side.
I'm not certain that that's true. And Mr. Preston can probably cite the cases better than I can, but I'm not certain that Open Table would not qualify. We applied as the church because we are the property owner, and it is a church project in cooperation with these others. But Open Table itself, I would argue, is a religious organization, and it certainly is doing this work because of its religious beliefs.
Do you want to speak to that?
I would like to speak to that for a moment. Open Table, our LUPA, by its terms, is not limited to churches. It does not have to be some place of worship in order to qualify for the protections. I'm not familiar with the foundational documents of Open Table, but as an interfaith organization, it seems to me that it would qualify as a religious entity. I forget the exact wording of the statute, but it would fall within. Religious interfaith or faith-based nonprofits do qualify for protections under our LUPA. The DOJ guidance, Department of Justice guidance, is very clear on that. As a tenant under that lease, they would have standing to vindicate those rights under ARPA. Yes.
Any other questions? Okay, thank you.
Thank you very much.
We are now going to hear from Councilman Freeman, unless...
Mr. Chairman, if I may remind you, we added 5 minutes to be used for rebuttal purpose by the appellants.
That's right.
Then we would hear from the council member thereafter.
Let's hear from the other side for 5 minutes. So please come forward.
Thank you very much. I'm going to speak really quickly and then turn it over to some of the folks that are neighbors and members of the church.
Well, Counselor, you know, this is a period of rebuttal, so we're supposed to basically speak about rebuttal during this time.
Yes,
but I guess
that's what I'm going to do.
Okay.
Yeah, I intend to address the things that they brought up. That's what
and your colleagues, too.
Yes.
Yes,
Mhm.
okay.
They're going to address things that were testified to or spoken to by other people.
Okay.
So the question here, as you know, for you all to decide, and I listened to all the questions, it almost sounded like a typical zoning hearing or a planning commission hearing where you were digging for facts and for information to weigh whether this was a good project or not. That is exactly what the neighbors want to have happen. And with the grant under RLUIPA, that would have exempted and does exempt this group from a great deal of that kind of analysis. So what we're objecting to today is the grant of the accommodation. And the other thing that came up in listening to this, it's very clear that the real applicant should be Open Table Nashville, and that neither Mr. Herbert nor this board should be relying on guessing what foundational documents say, terms that are pretty vague. I haven't heard whether Open Table Nashville would exclude an agnostic person from participating with them. I suspect they would not. They're very nice people. And is it a faith-based group? The lease says that the church, it says, whereas lessor, that is the church, is a religious nonprofit organization whose religious exercises includes homeless outreach. Then you get down to the lessee, which is Open Table, and it says, whereas the lessee is a nonprofit organization. It does not call it a religious organization. So it's very vague. They should have been an applicant. They should have submitted documents to Mr. Herbert to demonstrate that they do fall under the protections of RLUIPA. They did not do so. And we've had this hearing where things have been very vague and it's been dragged out. We've heard more from Open Table today than I think the neighbors have heard in this entire process. And we still don't know who these silent partners are. So I think what Metro should be doing is requiring the right person to file the application. It's clear the church has a religious conviction to enter into the lease. No doubt about that. They want to enter into or partner with this group. Don't question that at all. But the RLUIPA grant should go to the person who is actually building, operating, maintaining, and replacing and overseeing this operation. Otherwise, you're giving a grant to an organization that may not qualify under RLUIPA. That's our objection. And then, if that were reconsidered, then this process would go to before a board where these kinds of questions would be asked. We would know more about what is the medical condition, what are the transportation issues, all those things would be examined. But with this exemption they get under the accommodation, many of those issues are not going to be looked at. And what the stakeholders in this neighborhood want is to be treated fairly under the community plan and for these issues to be examined by the appropriate boards and not for them to be circumvented around by a lot of vague. It's still very, very vague. And if it had not been for some of your good questions, I would not have learned much of what I've learned today. So with having said that, we are still opposed and ask for a judgment. With all due respect to Mr. Herbert, he should have gotten a full packet from the right applicant, and he did not, and we think his ruling was in error. Now, having said that, I'm going to turn it over to these ladies there with the church, and they're going to...
I've got one question for you. So it sounds like you're saying the project should go through a rezoning effort in order to get the community meeting so the community can have participation.
That is exactly what we're saying.
What is your compelling, so we talked about the state and the federal religious law. What is your compelling interest that they should not be able to operate these 20 homes?
The cases that I've cited in my letter all say that RLUIPA does not exempt churches from the neutral application of zoning laws.
This is part of their mission that they have talked about, right? They've testified about that this homelessness and their outreach is part of their mission. So what's the compelling interest to keep them from doing it? they're saying that this is part of their essential element of practicing their religion. And so if you want to keep them from doing this, what's the compelling interest?
Well, first, the church has entered into the lease. They're not doing the work. So I would say that the church is compelled to enter the lease. They've entered the lease. They're not doing the work.
It was their testimony that they are in partnership and have been in partnership prior to this product with the organization.
If you've read the lease, that's not what it says. And you heard the testimony, really, Open Table Nashville is doing the whole thing.
But in partnership with the church was
a partnership is a specific legal term, and with all due respect to my great colleagues, it's been kind of thrown around in a cloudy fashion. I mean, I'm in partnership with you today because you and I are working on this issue together, and I'm in partnership. This young lady who's trying to figure out what I'm saying here and taking it down. So partnership has a meaning, and there's nothing in RLUIPA that takes that term and says, well, these people are partnering with other folks. I think that's been, again, with all due respect, sloppily thrown around, and it's not clear what it means. And I'm not even clear still. The lady who runs Open Table Nashville seems like a very nice lady, but I kept getting, at some points, I got the impression the bishop installed her at the organization. And then at other points, I didn't get that at all. So is this a Methodist organization, or does the bishop control who goes on the...
But I'll ask you again, because you're asking us to overturn the zoning administrator, and our lawyer talked about compelling interest.
Right.
You went to law school, you know about this.
I do.
What's the compelling interest here to keep them from having this tiny house village?
Two ways. The first, I have to answer that in two parts. The first is the cases have not held that the application of neutral zoning laws is a burden on religion. So you have to, that's the first thing. Then when you get to the compelling interest, if you found that, then you look at the facts of the case. You couldn't say to a church, we're not going to let you build anywhere. There would be no compelling interest. But that church that wanted to be in a house that was within 100 feet of other resident, they found that was a compelling interest.
We're a zoning board, so you get to make the higher arguments to Chancery Court about cases and things like that. We're just trying to ask you how you're preventing them from, we're trying to decide whether the zoning administrator was correct or not. And so I'm asking you, why is the zoning administrator incorrect in his ruling based on a compelling governmental interest?
The zoning administrator was incorrect in his ruling because he was not provided with full and complete accurate information from the entity that is operating, constructing, and maintaining the project. So he granted an accommodation to a different party that only entered into a lease. That's what he did.
Okay,
and
so
we're
that's
saying,
the main argument, that Glencliff really isn't doing this, it's really Open Table.
And it's not an argument. I think you've heard it here. They feel compelled. Glencliff feels very invested in the project, and they love the homeless, but they have decided they're going to let this organization come in and do this. That is true. I don't think the testimony would be against that. And then, so your next question is, if Glencliff were then, if I were to concede, well, Glencliff is the right party, and therefore, the first thing I would say is the application of neutral zoning laws is not a burden on religion. They can continue to be Methodist and do all the things they can do, but that applying zoning laws fairly is not the burden that RLUIPA prohibits. And then beyond that, I would say that a compelling interest would be to fair application of neutral zoning laws. And if you get to a place where you apply one unfairly and it's not neutral and you're shutting down a church, then RLUIPA is there for that. So.
But isn't that exactly what it does? I mean, what RLUIPA is saying, as I understand you, because the church is not zoned to have these tiny homes, they shouldn't be able to do it because the neighbor next door can't do it. And RLUIPA should not give them the right to do that.
Right. RLUIPA should not be used in this case to exempt them from the normal process that Open Table Nashville should go through.
So your argument is more than about the zoning. That's what when you're talking about the neutral zoning law, that's what you mean. Specific to this case, Because the neighbors
Right.
can't have tiny homes on their property.
Right.
The church shouldn't be able to do it either.
It's not that simple, but it is.
Well-
It has to do with the community plan that was adopted.
Right.
Everybody agrees this is how we're going to live by it, and if you want to change it, then you come before a board and you make an application. And that kind of a process gives a really good level of scrutiny to what is being done, just as you all did. You all had really kind of dove into scrutinizing the operation, and the reason you had to do that is because of a concern that it's not going to get done. They get this accommodation and they're home free, and it's not going to. And our neighbors just want that process done, like every other application. But if RLUIPA applied, then we would concede it would be fair to them. But we don't believe RLUIPA applies.
So I'm wondering if someone determined outside of this process, let's say someone determined that Open Table was a religious, this was religious activity that is protected under RLUIPA, could someone not make the argument, since they don't own the property, they don't have standing to get permission to do it?
No, standing is a different question in these cases. They've actually let a secular organization be the one to press it forward, but you have to show that the use and who is going to occupy and use it, that's where the religious action takes place. So standing is a separate question.
Well, so who decides then? So you're saying someone should be deciding if Open Table meets the RLUIPA
Absolutely.
guidelines.
That's exactly what we're saying. That is the
that is
question.
us, correct?
Well, it was your zoning administrator.
But now, since you're appealing that, you're essentially putting that on us.
And I think you're deciding whether what he did was correct or not. I don't know if this is a de novo hearing or
This is item A, so we're just determining whether our zoning administrator is correct in his opinion or erred, and we overturn his opinion.
Right.
That's all we're deciding today.
And do you look at what he had at the time, or?
Yes.
Okay, so what he had at the time was none of this information, and we're saying as a body they should go back and provide this information. There should be foundational document Open Table Nashville. The
But it
lease
will
should be examined.
up to this board to determine if the later information is material and relevant to his, if he had it, would his decision be different, or would our decision be different?
Right. But as I listened, with all due respect to this board, it became clear to me that the real applicant was Open Table Nashville, and hence it took some doing, but finally that person came forward, and you all had lots of questions for him. But I think it would have been better if that had been done more precisely and we had documents, so we weren't doing it in an ad hoc manner, and your zoning administrator could look at that.
Well, I guess when I look at the letter that Glencliff United Methodist wrote to Mr. Herbert, and this is in December last year, the 12/30 letter.
Yes, sir.
And it starts, for years, Open Table Nashville, in partnership with other homeless and affordable housing advocacy organizations, has been considering the needs for our homeless community. I mean,
correct.
Open Table is identified
As
right
a homeless
up front.
advocate, yeah.
Well, as someone who's, and then it sure does seem to imply that, I don't start a letter saying, hey, Dick's a good guy, but this is what I want to do. I mean, the reason the Open Table was mentioned in the letter is because they're part of the team.
I agree with that.
So I guess, what more information would the zoning administrator had to have had?
I would think that he would need to know the nature of Open Table through its foundational documents, whether it is in fact a religious organization, and make a determination whether providing shelters for homeless people is a religious act. I think it not necessarily is. It's a great act, but I know agnostic people who do that, and they're not engaging in a religious act, but they're very giving. And the thing is, RLUIPA doesn't protect them. They can't say, I would like the RLUIPA exception. That's the only thing we're talking about. We're not criticizing, I'm not criticizing these people, and certainly the Methodist Church, but I'm saying, RLUIPA has a very specific use and it applies in a very specific way, and we're questioning its application here.
Yes, but in this, I want to make sure that I'm understanding the language. When you're saying providing for the homeless or caring for the homeless is not a religious act, that's not the question. Isn't it whether or not the activity is central to the mission of the church that we're looking at? Not whether, in general, caring for the homeless is a religious activity.
No, under RLUIPA, the core question is whether the activity is a religious activity.
And then so the question is not, does it have to be a religious activity for every
For RLUIPA
purpose?
to apply?
Well, I understand for RLUIPA to apply, but I thought we had agreed that in this case, caring for the homeless was central to the mission of this church.
It is.
Okay.
And they entered a lease, but they are not doing the caring for the homeless.
Well, I know if I pay somebody to cut my grass, I feel like I'm still taking care of my own yard, even if I'm not on the mower. Is it really different from that?
I think you could hire a contractor, for example, if you have religious activities in a building as a church, and if you want someone to clean up the building, you could pay them. But that's not what's going on here.
Well, what about religious organizations whose critical mission is to raise their children to be upstanding, good citizens, and a means for doing that is to rent, to the Boy Scouts and Girl Scouts for $1 a year.
That's a great example. The Boy Scouts can't get a religious RLUIPA waiver. When they built the center there on the corner of Woodmont and Woodmont and Hillsborough Road, they can't come in and say, hey, because we're releasing space from Woodmont Baptist Church and we want to build a building, we want to come under RLUIPA. And Woodmont couldn't file the application and say, we believe in the raising of boys, but we're turning it all over to this group because we have neither the means or the method or the numbers of people to get this done, so we're going to turn it over. That application would be a Boy Scout application, and it would be examined by Mr. Herbert as such, and he would look at RLUIPA and determine whether the Boy Scouts were religious or not. And again, if he says there seems to be, there's a lot at stake here, but in a way there's not. What's at stake here is if he determines they don't get an accommodation, all they have to do, they go through the process, and then they go through a hearing, and the staff examines what's going on. They look at the questions that you ask in more detail. What is the transportation plan? How sick are these people? Who are your partners? Are these going to end up being medical facilities? Do you have medical people on? All that kind of thing gets hashed out in a better way in a real planning and zoning process, not through exemption from it. That's all we're saying.
And so you're saying that if we found in your favor and Open Table then applied for this, you'd be right back here if he said.
It depends on what they submit. But right now, I'm looking at this lease. It doesn't say they're religious when it says the church is. I heard an interfaith. I heard the term interfaith, but I think this is not under oath.
That just means different faiths.
Pardon?
Interfaith just means different faiths, not one.
I know it. I know that's what it means, but we would want to see the documents. You'd want to see the bylaws. You'd want to see the charter instead of just relying on kind of a. And the other nice young lady who was.
We don't ask for all that from church. I mean, when we're talking about the Methodist Church, it has. It's
well known.
It has a little name recognition. Right. But if we had a case come before us from Pastor Bob's Church of the Holy Sandal, and he said he wanted to have build a sanctuary on a piece of property, we're going to say, what are you going to do? Because I'm going to do religious services. I'm going to preach the word. Well, you know what? That's about as far as we're going to go according to federal guidelines. I mean, would you disagree with that?
I would, because look at what's happening in Madison right now. That's what the guy in Madison did. And then the zoning people went out there and they had a sex club going on.
Well, that was a show cause. That's a show cause issue.
Well, they should look at real documents. They should say,
so
okay, Pastor Bob.
We got to look at Pastor Bob's
sure.
seminary degree?
No, not a seminary degree, but you got a charter and you got a Secretary of State certificate, and here's my charter and here are my bylaws.
I think we're getting
That's
a little
not,
I think we're getting a
with all due
little off
respect,
here.
that's not really very high burden.
Wait, I think we're getting a little off topic. We're here to decide whether the zoning administrator was right or wrong.
I'm doing my best. Thank you.
And these kind of, examples or comparisons are not going to, be on point to what we're trying to decide here. So I will ask you again.
Yes, sir.
Because it seems like your main argument is the wrong person is applying. But let's assume that the church is the right person to apply, and they are duly the right person to apply. What is the compelling interest to stop them from having this tiny village?
The only interest I know that the metropolitan government has is the fair application of their zoning laws. And so it would depend on what the facts were and what they decided. So if they were going to build, I haven't seen a prototype, but it's supposed to be code compliant. If they submitted a plan that had a very minor problem, let's say it was a foot wider than some other micro home, I'm not sure that would be a compelling interest. But there could be other aspects of that micro home that could be compelling interest, and so it would be very fact specific.
But you're representing neighbors, I'm assuming. So
I am.
How does what compelling interest from their perspective would keep this board from granting these tiny homes on this property?
I think the failure to go through the process where it would be clearly delineated what's happening with safety, screening, transportation, the things that affect public safety in the neighborhood that are not going to get a clear and good look by an exemption from the zoning and land use laws. I think those bodies that do that, they have staffs that, as you know, that look at those things more carefully, and they can put the applicant through a more rigorous fact situation than you can when they're exempted. That's the best I think I can do, because I don't know what the specific finding would be.
I don't think they have to go through a more rigorous than anyone else. That's what this board is for. We're not saying because this is a church, they have to go through a more rigorous, and a matter of fact, RLUIPA probably says the opposite.
Right, that's why we're fussing, because under RLUIPA, they don't have to go through it. That's what we want them to go through what everybody else would go through.
Right.
Right. I think that, and so depending on what the facts were, there could be compelling reasons to turn this down.
Well, that's what I'm trying to figure out. What are they?
Well, based on just...
Pardon me, but I think in defense of this man right here, he's not trying to argue that point. His argument is that they misled the...
Yeah, no, that's his argument that the wrong person is applying, basically.
Yes.
I get that.
Yeah, so your question is a good one, Mr. Chairman, and I'm certainly trying to be responsive, but it does depend on facts. A compelling interest is always fact-dependent. So I don't know what I've heard unsworn testimony. The only document I've read is this lease, and I just got it today, and so it's hard to conjure up, well, if they came forward and put on a case, what would be the compelling
This isn't a court of law. We don't swear people in. As John Michael said before, if someone gives false or misleading testimony, that's grounds for us being able to reverse anything that we gave them.
Both sides are equally unsworn.
Yeah, that's true. But also, again, to point out, it's important that before you get to the compelling interest, you must show us a burden, a substantial burden. And there's not a substantial burden here. These folks can still minister to ask them to go through the zoning process is not a substantial burden.
Any other questions?
Oh.
So you have 50...
These young ladies, these
okay, you have about a minute.
Neighbors.
So.
Okay, go right ahead.
Hello, my name is Risa McAllister, 3511 Hewlett Drive, Nashville, Tennessee, 37211. I not only live in this neighborhood, I'm also a member of this church. So obviously, not all of us members are for this. We're not against helping the homeless. However, sitting there today, I'm hearing a lot of misinformation given that I'm just very hurt over. Things such as the congregation went to the minister and asked to do these homes, and that is just not correct information. The pastor came to the congregation. This was once again after they allowed Open Table Nashville to come into the church and rent the whole bottom half for $500 a month and a third of the cost of the utilities. So I think there's just a lot of misinformation being given, and it's kind of the odd timing of everything. It's not that we've never helped the homeless through the church. I grew up in that church. We definitely did, but we never had projects such as this until Open Table Nashville arrived on the scene.
Our time is up.
Oh, I'm sorry.
Is there any questions?
Ma'am, did you have anything you wanted to say? That'll be my question.
Well, yeah, sure. With the infrastructure the way it is in South Nashville right now, I feel like it's going to be a burden on the Thompson Lane area with the little homeless houses over at the church. There's not enough room on the sidewalks. They do have to cross over the interstate, over a bridge. But it's very dangerous in that area of town, especially right now where they've sold the Boys and Girls Club, and we still don't know what's going in there, and all the new apartments and condos that are going down Thompson Lane. There's not enough red lights, for one thing.
And ma'am, if you could state your name and address, please.
I'm sorry, Deborah Wheeler, and I live at 218 Chilton Street, 37211. I've been a resident since 1964.
Very good. Any other questions?
I do. You mentioned the church has been serving the homeless in other capacities in the past. Can you tell us some of those ways?
Definitely. I know for a fact that we've always done things like the mitten trees, because I've always supplied mittens for the tree because my mom is real big into things like that, which are given to the homeless, not only mittens, but also socks and hats and blankets. Also, the room at the inn, it's affiliated, but they've never directly done work with them. They've gone and served at soup kitchens in East Nashville and served them plenty of times. But I just feel like nothing to this magnitude was done until Open Table Nashville arrived on the scene at the church. It just seems odd to me.
Any other questions? Thank you. Now we're going to hear from Councilman Freeman. And thank you for your patience, and here you get to close us out.
All right, well, again, this is my first time before this board, so I figured I'd make it a good one when I showed up. And I'd also like to apologize to those 3 cases that are behind us. You've had to sit through and listen to this and go back and forth, but just know that this is a very important issue. It's important to both sides. It's important to the homeless community, and it's important to the church. It's important to those in opposition.
Apologies to everyone except the lawyers who are getting paid by the hour.
Exactly. But I want to touch on a few things that were brought up on back and forth. When you talk about how this project came about because it was originally slated for Madison. That church pulled out of the deal, and this plan was already in place. There was already a mission to do this. And so, because I can only assume, I'm making a wild assumption right here, that Open Table Nashville was already renting space from Glencliff United Methodist Church, that was the natural progression to approach the church and try to secure the land. And I would also like to say that in meetings that I've had with the director of Open Table, she saw this as a way, her words, to let the church die with dignity. And so I wonder, how is that your mission if that is exactly what you've said to me? And then we also ask about compelling interest. What compelling interest does the city have to prevent this development? We've also heard that these are going to be the most vulnerable. We know we're going to have hospital patients. Hospital patients have opioids. And so at this point, that is a safety concern for both the residents of the village and the neighbors, because we are hanging a shingle out and says we have vulnerable people with opioids. And so I would say that is at least a piece of a compelling interest to prevent this project from going forward. And closing, I would like to say that RLIPA and RIFA, I've learned a lot. You guys, I know that you know it forwards and backwards. Bill Herbert, John Michael have given me a crash course, and from what I've understood, RLIPA and RIFA tell us what we can't do. There's no clause or no statute that says what we can do. And so I question, the church is already on the mission to serve the homeless. But does that mean that we as a city can allow them to build a tiny home village? We are not preventing them from serving the homeless. That mission can still go. All we're saying is you just can't build a homeless village. And I would just compel you to say, look at that, understand that Glencliff United Methodist Church is not the main player. This is other players involved, and I think that that is why the letter presented should be withdrawn. And I thank you.
Any questions for the councilman? Councilman? Thank you. Thank you. So we're going to close the public hearing, and before we get started on our discussion, I want to ask our lawyer again, since the councilman brought up RLUIPA and the federal law, remind us again about those two laws and what they say and kind of how it relates to this particular matter.
Well, first, as Mr. Herbert has pointed out, this is an item A appeal of his reasonable approval of a reasonable accommodation. As was pointed out earlier, the application was for a reasonable accommodation pursuant to the Metro Code. 17.40.010H says the zoning administrator shall make reasonable accommodations in the provision of this chapter in the rules, policies, and practices of his office so that the rights established or recognized under RLUIPA are protected. So that's why we're here today, and that's how the law with respect to RLUIPA and RFRA.
So once again, we're here to decide if he's right or wrong.
Correct.
And we will either affirm or overturn his ruling. But yes, continue on this RLUIPA.
Right. So you're here to evaluate if the application of the zoning code would impose a substantial burden on the free exercise of the religion. And if you, based on what you heard today, again, you have to evaluate if the application for these micro homes and the reasonable accommodation, if it was not granted, would that be a substantial burden on the free exercise of the religion? If you also need to look at, does Metro have a compelling interest? And if there is not a compelling, or if there is a compelling interest, is the application of the zoning code the least restrictive means of achieving that interest?
To boil that down to the facts of this case, though, is what we're determining is essentially, could you say to this applicant, you need to apply for rezoning, or do you look at it under RLUIPA? I mean, that's really...
Well, I don't think the applicant is precluded from applying for rezoning because they're a church. I think they...
No, I understand that. But I mean, that's the alternative. If the accommodation is, because we're a religious institution, we want to be able to build these homes. The alternative is they ask to rezone the property.
That is an alternative, yes.
Is there another alternative?
I don't think so.
Okay.
And I guess the only question I have is that, the issues that you raised were issues that the zoning administrator took into account, and based on the information presented, judged that yes, it would impede on their right to exercise their religion, and therefore they're accommodated. And so the only additional information that I think we got was this partnership, and I don't know how loosely I'm going to use that word, but this relationship, say, with Open Table. And is there anything that you heard about that kind of partnership or relationship structure that would cause this not to be protected under RLUIPA?
Well, I think that I haven't reviewed the lease. It was made an exhibit, but I have not had an opportunity to review it. But I think that there is an argument to be made that Open Table is administering this program that the church is calling a function of its ministry. again, I haven't reviewed the lease, so I don't know the terms, and I don't know how that would be, what the final answer would be. But I do think there's an argument to be made that they are administering this, that they are administering it versus renting it. That's what I heard. Again, I haven't reviewed the lease, so.
And I'm asking, and I know you may not have the answer because it might take more research or be complicated enough to not really have a clear answer, but my gut just said, well, why is there a problem with, a church getting a related expert to conduct their mission? And of course, the folks that are asking us to overturn this said, well, there's a real big problem with it. And do you have any thoughts on how we should think about that, or is that?
Well, our LUPA prohibits zoning laws that substantially burden, again, the religious exercise of churches or other religious assemblies or institutions. Again, absent the least restrictive means of furthering a compelling governmental interest. So I think it is very fact-specific, and I think that y'all can look at Open Table and determine, does it meet, that definition? Is it carrying out the church's mission? Is it necessary to carry out the church's mission? Would not allowing this or did not granting this accommodation, would that substantially burden the church's ability to carry out their mission? So again, I think it's fact specific, and it's something that y'all can look at based on what y'all were presented with today and making that determination.
Talk to us about least restrictive means, because we haven't really talked about that much. So we talked about compelling interest, but basically if you do restrict something, there's a way to restrict it, but tell us about least restrictive means.
Well, if there is a way to be less restrictive.
So, for example, if we allowed them to have these 20 tiny houses, but for whatever reason, if we came up with some safety or sidewalk issue and said they could only be on this section, not this section, that would be a least restrictive means, right?
It could be. Again, I think it would be fact specific, and you could determine things that could achieve the interest without restricting.
Keeping them from having their 20 houses.
Correct. Again, assuming that meets the compelling
interest, yes.
The compelling governmental interest. Right.
Well, and they no matter what, a religious institution, no matter what they're doing, has to meet, as we said, all other codes, but bulk regulations, bulk zoning regulations. So, they can't say, for instance, even if we said, yeah, this is part of your mission, we agree with that, but you can't put 1,000 homes here, you can't just stack them up. That's compelling, if I'm understanding this right. But that in no way is, saying as long as you meet the bulk regulations, you're fine. We're not giving them carte blanche once we do. If we said, yes, this is correct, we're not giving them carte blanche to break any other rules.
Well, and certainly they would have to comply with the other code provisions, so it's structurally sound, from an engineering perspective, other codes, other issues.
But essentially, if we uphold the zoning administrator, the church could decide to put more than 22 homes, or,
Mr. Herbert, could they do that?
So they would have to present a site plan to us. Each of the structures would have to be fully code compliant, meet separation requirements. We would approve a site plan that had a certain number, and they would be limited to that number approved on the site plan.
Mr. Herbert, there was a lot of talk today about your letter and your ruling and things that have come. So tell us what you based your ruling on, what material you had, and when you made it.
I had the letter from the church.
Mm-hmm.
The church made the request to use its property for these purposes. and I based my determination upon the information contained in the letter from the church based upon the church's request.
And I'd like to ask Metro Legal, is there any obligation of the zoning administrator to determine how that request is going to be carried out, either in just literal or physical or legal terms?
I think the zoning administrator is required to analyze what is put forth before him. If there are holes, I think he has the discretion or authority to ask for more information, but I don't know that he is required to.
Do you have anything else to add, Mr. Herbert?
No, I don't think so.
Okay. Any other questions before discussion? Okay, discussion.
Okay. I'll start. I have looked at the zoning code where it calls out religious institution, and it talks about new facilities and sanctuaries and number of seats and cemeteries, and it does not mention homes. And so I do believe that they should go through a rezoning process because these are homes. And I believe they can accomplish what they would like to accomplish by going through that process. And I don't think that we are putting a burden on their free exercise of practicing religion, their religion, because they have already been serving the homeless in other capacities in the past.
I feel like in past cases when we've discussed this type of RLUIPA type issues, that once there's a determination of the religious activity to fulfill their mission, that's kind of the end of the story. The how and the what, we don't get to say what color the stained glass is or any aesthetics. Again, code has to be met, but I think that the story ends at a determination of the mission, of what the religious institution feels is their mission, or what they say is their mission. That's the authority. And beyond that, then we get into the compelling issues. But I think once you get to the is it the mission? Is this what they feel they need to do? Then that's where the discussion stops.
Yeah, I think that based on our previous cases, I think that holds true. Thinking of the special exception that had a lot of neighborhood folks that didn't want the religious organization to be in the neighborhood, and gave many examples of probably more appropriate places that religious organization could be. And our attorney at the time had said, well, that's just not for you all to decide. They've determined that this is a place where they need to be, and it's basically, unless there's a compelling government interest, and the only one we could determine was the safety of the street, which they accommodated, and we really were kind of told by our legal counsel we didn't have a right to debate whether it was appropriate for them to do that at that site. So, this is obviously a hard case. We've been here all day, and I get it. I have great empathy and for the neighbors. I have great respect for the council member, and for the folks that are wanting to serve an important need of our community. And I guess my gut when it comes down to it is, have I heard anything compelling to overturn the zoning administrator? And I'm struggling with it. I haven't heard that yet. So I'm open to it if you have the pathway for it. Do I think that the process was handled in the best way possible by the folks wanting to build this? Probably not. I think there's enough angry and upset folks that have written us letters and have said, we didn't have information. We learned more about it today than we've ever had. I get that, but is it an important part of their mission? I think all sides have agreed that helping the homeless is an important part of their mission.
Well, and I agree that although Mr. Ewing asked 3 or 4 different times for a compelling reason not to allow them to go forward, I never did hear any compelling either. I didn't feel like I heard your question answered at all.
Well, and to me, it's not a question, and I want to make sure that this is clear to the folks in the audience as well as to my own self as I'm thinking about it. This, we're not here talking about is this a good project or not? Is this the best project or not? Is it good for the neighborhood or not? I mean, the question that we're asked is, did our zoning staff and our zoning administrator err in writing this letter? It's a whole different standard, and it's and I appreciate the appellant's the opposition's argument that it would have been nice to have gone through that big long process, but the rules that apply here, or were applied here. Our zoning team has said, no, this is a religious activity, and this is the process that they're supposed to go through. And so to me, it's what is the argument that says, no, they erred? And that's what I'm struggling with.
I agree with Mr. Taylor. We are dealing with 2 very important religious freedom laws, one at the state level, one at the federal level. And because of that, the compelling interest argument is very key to our decision. And I asked, as Ms. Sanford said many times, what is the compelling reason to keep them from having these houses? And outside of just the wrong person applied, there really wasn't one. And to me, given that, and that Mr. Herbert, getting back to his item A appeal, made reasonable accommodations about this particular case, I don't think he erred. And I also agree with Mr. Taylor that the way that this was set up and communicated and even structured with so many different parties and lawyers and leases, and that was not very good. But at the end of the day, the religious freedom, state and federal law apply, and the opposition has not shown us any reason why we have a compelling interest to keep them from having these homes.
I have the greatest respect for our zoning administrator. Normally defend him to the very end. But I've seen cases where afterwards things have come up that he found interesting and knowledge he didn't have beforehand. I don't believe that he was granted sufficient knowledge to write the opinion that he wrote here. I think he might have erred because he didn't have all the information. So I got to say, I suspect that he might have been misled to be.
Well, I'll offer a motion. Sounds like we're in a position to vote and see where it goes. And we're all here, so that's something. I move that we find that the zoning administrator did not err in his opinion.
Okay, we have a motion. Is there a second?
I second.
Motion has been made and properly seconded. Any more discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? So it's 2 against. 5-2.
Motion passes 5-2. The item A appeal is denied. The zoning administrator's position is upheld. If the deference to the board, would be glad to take maybe a 3-minute break to allow the room to settle so we can take on 3 more cases.
That's fine. Thank you.
Respectfully, we would ask members of the public who do not wish to stay to exit quietly so we can proceed promptly. And ladies and gentlemen, we will reconvene with the Board of Zoning Appeals meeting, which is still in session, with 3 more cases to follow in another minute. Just another minute.
Board of Zoning Appeals is now back in session.
Yes,
Case
sir.
number 2017-123 is the next case to be considered. This is the property located at 926 Marina Street in East Nashville. The request is for a variance from side setback requirements as part of the expansion of an already non-conforming structure, a legally non-conforming structure. As the aerial shows here, an older iteration of the property is actually built very close to the property line. If you'll forgive my use of the arrow indicating just to the left of this structure. Less than 2 feet away from the property line as constructed many decades ago. The proposed plan is to expand that somewhat, utilizing the same setback. This is a contested case. So we'll hear from both parties, and they both have 15 minutes to make the desired presentation. From my recent site visit, the face of the subject property from Marina Street, the views up and down Marina showing the other parts of the neighborhood. Here in the upper left-hand corner, the view directly across the street, and a little more view of the construction underway, albeit on the opposite side of the property in question in terms of what's in play.
So what, they're adding on to an existing home?
They're adding on to an existing home.
Could you go
The
back?
existing home has a legally non-conforming element in that it is within what would otherwise be the existing required setback, a little less than 2 feet off the property line, whereas the side setback would normally be 5. They wish to expand the existing home to the rear. That rear expansion would also be in the setback with the, and I'll let the appellant describe exactly how much, because I don't think the site plan that I had in hand necessarily gave you a whole lot of detail in terms of
John
whether that was
Michael,
also 2
this is
feet.
very unusual. So how close is that house? Go back to the other slide, to the property line.
Less than 2 feet is my understanding, Mr. Chairman. Again, we'll let the appellant specify that. I'm sure they've got the more particular numbers.
Have they already started the addition?
There's actually work underway, but as to the legally non-conforming component, I don't believe so. This is, to the extent that it is, I'd have to go back and double-check the permitting on that. There is some work underway at the subject property, as you saw from my first photo there.
Okay, so let's have the applicant come forward. Who's the applicant for case 123? Is that you? Are they here?
And again, as final clarity, Mr. Chairman, it is a request for a variance, not an item D case for an expansion of a legally non-conforming structure.
Okay. Are you the applicant? Yes, sir. Okay. Please sit down, turn on the microphone, identify yourself with address for the record.
Hi, Gordon Gregg, and my address is Franklin, Tennessee, but this address is 926 Marina Street.
Okay. Let's go.
Yeah, I had some pictures here, if it helps.
Sure.
It shows
Yes.
both sides of the property and the property line, and kind of spells out how many inches everything is between everything. Yes, sir. No, there's, yes, sir, it's got one for everything. It shows all the angles and the additions. And originally, we started this home, and it was built, the addition has been done. The house is probably about a week and a half away from completion. There was when we did this land survey, the first plot we got was incorrect. The second one we had done, if you're looking at the pictures there, that's kind of the beginning picture, and then it walks you through the property line. You can see the original post on the corner of the front right side of the house is about 11 inches from the property line. That's when the house was built in 1920. When we came down the property line, we extended on the same line of the foundation, actually went to 48 inches away from the property line on the back of the building.
So why didn't you build further away from the property line for this expansion?
Quite honestly, it was a mistake. The error was made when we got the original plot. The 1920 plot was incorrect. And so when we had the land surveyed, we found out we were actually right on the property line. We had a bump out. There was an objection to one of the neighbors. What we show you is the original bump out, and then we went back and changed the permit, changed the plan. It was approved, and then we continued with the expansion and removed that bump out.
Why did you wait to have the property surveyed before you started construction?
It was an error on the contractor's part.
So did the contractor have it surveyed because he questioned, he thought maybe that's very...
No, actually, we did the survey because there's some trees in the back of the property line that we wanted to remove and make sure it was okay with the owner. Is there enough? You need another one?
I think we're good.
Good. You'll see where we had the original plan that was approved. It has the bump out highlighted in yellow, and that would be probably the third or fourth page in. And we also have the as-is plot survey. It was done when when we went down and changed the permit to meet the existing survey. And then you'll see the pictures of where we removed the bump outs when the bump out was there, and we found out there was a problem. It wasn't on the property line. It was the soffit on the top of the house that extends 8 inches into the property line. And then you can see the next picture shows it, and then we show where it's been completely removed.
You're talking about the bump out's been removed?
Yeah, it was completely removed.
Because
yes,
the bump out was on the other property?
No, it was not on the other property line. It was within the easement, right? It was
in the easement.
Yes, sir. 8 inches into the easement and 10 inches down.
So why'd you remove that part and not the other?
Because the other part was already in existence, if you look at the picture.
Oh, but the bump out you hadn't built yet?
No, the bump out was built, yes, sir, on the existing foundation line.
Why'd you remove?
Wait, to be, okay, there's the original house, and then there's the addition. The addition had the bump out that we're referring to.
Part of the original house and part of the addition, because we had extension, was on that, is in that split of the sections, 25 feet.
Gotcha.
Right, and we went with, when we spoke with zoning, and I wrote down, you can see I wrote down the number of inches and where we got away from it. And in speaking with them, they said as long, it's been the position of the zoning group, as long as we stayed within the line of the original foundation, which we did, and you did not impede closer to the property line, which we did, and we actually went further away from the property line with the extension. We worked to settle with the particular neighbor, but the figures just didn't seem to work.
You mean settle like by
To seek an easement for the 8 inches.
Okay, gotcha.
Yes, sir.
Okay. Anything else? You'll have some time for rebuttal, so we'll hear from the neighbor in opposition, and then you'll be able to come back.
No problem at all. Thank you.
I have some paperwork.
Sure.
I only have 4 sets, but.
That's fine, we can share. So please sit and identify yourself for the record and your address.
My name's Eric Quorum, and I live on 1616 Holly Street in Nashville, Tennessee.
Mm-hmm. So you own the neighboring property?
I do. I own the rental next door. And so the current structure that I own at 924 A and B, it actually sits 14 feet from the surveyed property line, adjacent to Mr. Griggs' property. If I was just going to keep that as a rental, I wouldn't be here today, but I'm actually planning on building a duplex there, so I'm going to need all of the 40-foot allowable setback, with the 5-foot setbacks on each side. So it's a big issue for me. The main point is one of value. So my position here is one of the value, the future structure that I want to build on this property. I understand that the original structure in 926, Mr. Griggs' structure, cannot be moved. It's grandfathered in. I'm not asking for anything there. I'm just simply saying that my issue is with the current portion that Mr. Griggs is building. He chose to tear off the 11-foot section of the old house, which had a low shed roof facing the rear of the property. It's in its place, he built new construction, so that's my main point. As soon as he broke ground with the footing, that falls under new construction guidelines and setbacks, and he knows that, and the rules should apply to him in that way too. So my issue is that he didn't follow those rules. So on the permit that he pulled, which you're looking at, you have a copy of the permit there. The permit officer, I'm not sure why he was not required to do a survey to begin with. I don't know why the codes individual didn't actually demand that of him. I'm actually kind of in the dark on that. But you can see on there that the codes official said on the 25-foot section, there's a circular mark there. It says minimum 5-foot setback, and he didn't comply with that.
On this picture right here, are you to the left of him?
Yeah, I'm to the left.
And is that currently a duplex?
It's currently a duplex.
Okay.
So by right, I could put back a duplex as long as I meet the requirements for electricity records and things like that.
And it looks like, I mean, does the opposite side of your lot, I mean, it looks like, according to this map, that your house is kind of right on the line too.
Well, those maps are notoriously not super accurate, but I think I'm within the 5 foot on the other side as well. But it doesn't really matter because I'm going to be tearing that structure down, and then I would have to comply with both 5-foot setbacks with whatever I put back on that lot.
And so you're saying that?
My point is that he needed to jog over to meet the setback, the 5-foot setback. And because he didn't, his house, and I've got the numbers here, I just measured it yesterday. I walked out there yesterday. The front portion of Mr. Griggs' new construction, where he started the new construction that's permitted, is 2 feet from the surveyed property line, which means his eave is actually 1 foot because the eave comes out a foot. The back corner of Mr. Griggs' new construction is 3 foot 4 inches from the surveyed property line, which means the eave is 2 foot 4 inches. So if I put a house there at 5 feet, and then if I put an eave, you can imagine how close they're going to be. So I think he's creating an undue burden upon me and reducing the value of what I'm going to build, because anybody that comes and looks at it and is going to say, why is this house right next to yours? Why is it so close? And actually, he's taken advantage of, in those pictures, he's taken advantage of the extra room on the other side of the house by building a wide deck. So my position is that not only would he be taking value away from my house, he's actually utilizing the fact that he's shuffled over so far to add value to his own house. And ultimately, Mr. Grigg could have avoided this because he could have done a survey. A good builder knows that you can't rely on telephone poles and fences to give you a survey line. He's asking me to absorb his mistake that he made, and I don't think that's really fair. Additionally, he also could have called a footing inspection, and the inspector would have caught this issue right from the get-go. He could have saved a lot of money, but he didn't. He called in an engineered letter, and an engineered letter is fine for testifying to the strength of a footer, but not the placement, right? I mean, that's not how it works. So I have 2 choices, neither of which are great. One is to be forced to build my structure farther from the minimum setback just to have some room to breathe, so to speak, or I have to build a home that's right on top of this other house. While I comply to the 5-foot setback that he's not complying with, his house is going to be right on top of mine on this portion. I just feel like that's unfair.
But you have to do that anyway with the old house, right?
That's what I was going to say.
I mean, the old house is grandfathered in, so at least 2/3 of the issue that you have would be 2/3 there anyway.
Well, it's not 2/3. It's 20. The old portion is 27 feet. He added a 25-foot. So if this is a non-compliance, he's building this into non-compliance as well. He's doubling the footage. So this is non-compliant house. Now he's taking 25 feet and doubling it. I feel like that's a lot. So
because the front of the house is grandfathered in, and you're saying the back part, he should be stepped back.
Yeah, it should be jogged over.
Yeah, because you're not complaining about the front part.
No,
that's
I realize I can't do
1920.
anything about that. Yeah.
We could blame Mayor Gupton and his codes people, but so.
In addition, he has not been a good neighbor to my tenant. He's piled lumber up. My tenant couldn't get out and go take his trash out. After he did the survey, the property line is very evident because he did the survey, and he has bricks all over on my side of the yard for weeks and weeks on end after the survey. You would think that he at least would have picked them up.
So what are the solutions here?
Well, I've offered him a settlement, but he's refused.
Okay. So what are our solutions?
I mean,
what are you asking us to do?
I would think he would have to we'd have to come to an agreement, the 2 of us.
Well, that's private parties. That have nothing to do with us.
Then I guess he has to tear off what he's built.
Okay. Questions?
So you're saying that this is not a hardship because he could have jogged it and moved over? I mean, it's a kind of case where if he'd come without opposition, and I don't know how we'll weigh your opposition to this, because most of these, a lot of these don't have opposition because it's just something you're like, well, you probably shouldn't have done it, and there's a hardship because house was there, and I get that. But you're just saying that he didn't have a hardship because he had enough room on the other side to have jogged it over.
Yeah, he has plenty of room. And I feel like that he could have pulled a survey. He chose not to. I mean, why should I be punished for his negligence is my question.
Any of our architects have any opinions on or questions?
Sound like the neighbor not getting along to me.
I don't think it's unusual for a home addition to line up with an existing home.
But what about the survey part? When is it standard to have a survey done when you're doing a big addition?
Well, I would always advise my clients to have a survey done, but I don't delve into this small, or I guess single-family residential or two-family residential world, so I can't really speak to that.
Do you have anything else to add before we
what is the ruling? When don't people have to pull a survey anytime they build new construction? Is there an exception to that?
John Michael.
No, they do not.
They don't have to?
Not under Metro law. But, here's the consequences. You don't have to, but if you don't and something like this comes up, then it's a problem.
And then they create a board of zoning appeals to hear these cases.
So do you have anything else to add?
No, it's just that I don't feel like he's been a good neighbor, and
Well, let me ask you this. I'm channeling our former board chairman, Chris Whitson, now. Seems like you all have talked, but you couldn't come to any resolution of this.
Right.
Would extra time help this situation, or do you think that you're so far apart that you can't come to any sort of agreement?
That would depend on Mr. Griggs.
Okay, well, I will ask him that same question. So do you have anything else to add?
No.
Okay, thank you.
Thank you.
Mr. Griggs. So, first question out of the box. Would 2 weeks where you all can discuss this and maybe come to some sort of resolution where you don't need the board?
We actually reached out to him. He didn't even know there was an issue. I reached out to him and said, hey, I want to be a good neighbor. There's an issue here. The original plat, which he already has admitted, are incorrect because his house does sit within the property guidelines of the other property just as well as mine does.
So the answer to my question, though, is...
The answer is we offered to do something. We came with the figure, and I was told...
Would 2 weeks make you...
No, sir. $40,000 for 8 inches is not a fair figure. And then the next offer was $20,000 if I would pay it before this hearing, and he would not oppose me. And my client has said they were not willing to pay $20,000. So no, sir.
So rebuttal time. So
we had a work order. We turned in the permit as asked to do. The plans were displayed. We did adjust the plans when the do not work order was issued based on the overhang space. We corrected that, was given a go back to work order. In speaking with Mr. Herbert, he said it's typically the position of the group for the codes that if we are within line of the existing foundation and stay in a pattern that doesn't impede more upon the property but it lessens the problem, that it shouldn't be a problem. And we went ahead and built based on that basis to finish out the house. To move it at this point, obviously, is a whole nother issue. But so we felt like we stayed.
That's why I asked the question about 2 more weeks of maybe trying to come up with some stuff. Because we can defer this hearing.
Yes, sir. I can't speak for the client in this situation. My job was simply to project manage and complete it once there's an issue. So,
but if we rule today, that's the ruling.
So if we decide,
you decide.
I understand. We went on the recommendation of Mr. Herbert that the foundation line was, as long as we stayed within the existing foundation line and did not impede upon it, then it would be fine. So we went forward.
Mr. Herbert said that.
So
yeah, actually did, sir.
No, what I did say
Thank you.
was that this is the type of thing that the Board of Zoning Appeals would look at and be sensitive to. I did not say that this is something that we would approve administratively. Hence your reason for being here today.
Yes, sir. I don't mean to misquote you. My apologies.
Mr. Taylor started off saying, if there was no opposition, we'd probably look at it and not be happy, but say, yeah, okay, but there's opposition, and there's strong opposition.
Well, and the opposition has stated I think a reasonably strong case that there is potential harm, and so the other so in these kind of ask for forgiveness cases instead of permission, I asked myself, well, would we have approved it anyway? And so that's kind of basis, what was the hardship? And, it seems like the side yard that you have and the lack of visible trees and other things that I see on that side yard that says, well, no, you probably could have done it. You probably could have moved it over. He says that to me, there's a good case that it's kind of 50-50 for you. And
So
it kinda
the
goes-
question is
which kind of
again-
goes back to say, one of you is going to be really, really sad.
Exactly. So one more time.
And so
with a 2-week deferral where you can get together and maybe come up with some settlement where you don't need us to rule on something.
Yes, sir.
Help.
I can't,
I would
obviously.
add to that, I think they're trying to give you a good.
Yes, sir. Yes, ma'am. I understand. I'm just
What
trying.
I would suggest is, if we were to grant what you're asking, then what it means is likely your neighbor is going to have to come back and ask for something from us as well to
Yes,
build
ma'am.
his structures. And maybe you could talk to your clients about how that looks in the future.
Yes, ma'am.
In the event that they do not challenge that at the Chancery Court of Davidson County.
Yeah, the losing party obviously has the right to go to Chancery Court and state their case of why we were wrong.
And I appreciate your strong recommendation. I'd like to stay with that. Yes, the 2 weeks would be great if we can find a solution.
Very good.
I move that we defer this case for 2 weeks.
Okay. Motion's been made, properly seconded. No any discussion? Seeing none. All those in favor signify by saying aye. Aye. Opposed? So my suggestion on this 2-week period, because as someone that's been on the board for a while, this is a complicated case because you've already built, you didn't have a survey. I would try to find some sort of way to resolve this.
Yes, sir.
Or you can balance your financial cost of if this board were to rule that you have to move this addition, how much that would cost versus doing something with your neighbor.
Well, and I can't speak for my colleagues, but I also would say, I don't look at this as anyone going away with 4 aces, right? I don't see either one of you having, a good solid, hey, I'm going to win this, so I'm saying it's probably a good case to really work something reasonable out, whatever reasonable is to you all, but don't leave your
He said 50-50, so yeah, to the neighbor over there, we could go either way, but we think as a board, particularly since the options are, this or that, and there's no kind of compromise, we are hoping that
We
there's
can
some
come to
sort
a
of
compromise.
Yes.
Yes, sir.
And if you can't, then we'll decide, and somebody's going to win the coin toss.
I understand.
Okay, thank you.
Thank you so much.
John Michael.
With that case deferred, the next case to be heard by the board is number 2017-124 involving property located at 751A and B Linwood Avenue. This is in Council District number 17, just off the 8th Avenue South corridor as you're approaching 65 going southbound. The request is for 2 variances, one from the lot size restrictions and the second for the side setback requirements in this, the R6 zoning district. The property seen here as indicated for HPR development with the highlighted area in the zoning map shows the R6 area in question. The aerial, obviously now dated, and forgive the marker that's in place 2 properties down, is actually should be for that which is showed is about the 3rd house off of the street here. The site plan submitted gives a projection of the layout for the proposed development as conceived by the developers. And from my recent site visit, the smoldering pile of ashen heap is the proposed development site that Mr. Cleveland brings to you today. The view across the street shown here as well as the view up and down the street. Although the appellant is Barry Cleveland, on behalf of Thomas Teague, the owner, I believe that the parties are in fact represented by Mr. Lefevre as well. With that, gentlemen, you appear to be unopposed on your case. You will have 10 minutes to make the desired presentation if in fact you need that much time. Feel free to introduce yourself to the board and make the desired presentation.
Hi, my name is Barry Cleveland, 95 Whitebridge Road, Nashville, Tennessee. Adam's going to be presenting the case here on behalf of myself and my client.
And 2 things I want to get on the record. First, Mr. Teague has since died since this application, so he's no longer the owner of the property. Second, I'm an interested owner in the property, so I want to get both those things on the record before that. This is again, a 2-prong request. One is a lot size variance, which I know is relatively new for the board to be able to rule on. The total lot size of this is 5,000.
Do we want to give it?
Looking for my number.
57.
5797. So it's 203 square feet short of the required amount.
And before you get really started, I want to read an email we received from the councilperson in the district, Colby Sledge, as it relates to this particular property. He says, I support this request for variance from lot size restrictions and setback requirements. The lot falls barely short of 6,000 square foot minimum. I've spoken to the applicant about their plans. I feel comfortable with this request.
Right. So I don't think there's an issue with the lot size. As for the setback, just wanted to let you know, we are not planning on moving the house closer to the neighbor. The setback is so we can move the houses more towards the middle and have the houses be the same size. So, any questions?
I don't understand. It's a vacant lot now, right?
Now it is. It was torn down, yes. It was a shotgun duplex before.
So it's torn down and you're going to build 2 more attached or detached?
Detached.
They'll be attached.
Yeah.
And so I guess I'm perfectly comfortable with the lot size variance because it makes sense to me. But the setback variance is one I'm just not sure about. I mean, what's the hardship to for you to need only 2 feet instead of 5?
I have your answer. I was anticipating that question. The property next door is also same owner. And so instead of building 2 structures, one on a 43-foot lot and one on a 50-foot lot with the same setbacks, this will allow all the structures to be the same size instead of having a big one, little one, because of the 43-foot lot. And so the only affected party by the side setback variance is also the same owners that's requesting the variance.
So how much space is going to be between the 2 buildings?
That's another issue. Codes requires 10 feet. That's the point of the restrictions, and there's still going to be 10 feet between the buildings. Right. Or there's still going to be 10 feet between the buildings, even though the setback is being reduced. So it's still going to be 5 feet from the buildings on both sides.
So it's the same owner now, but inevitably, I'm sure the lots will be sold? Is that the goal?
Once construction is complete.
So then in the future, if someone wants to add on to the back, it's going to be the same situation we just saw in the prior case, if the lot line's not moved?
It would be quite a chore to add on to the back, being that it's a horizontal property regime. And I wouldn't anticipate that to ever happen for one neighbor to agree to allow the other neighbor on a joint property to build in addition.
Are both lots going to be in the same horizontal property regime?
Yes, all the properties, almost all the properties over there that are being torn down are.
And that regime exists?
Yes.
So the lot that you're talking about next door is all part of that regime, and
it has to be 2 separate ones, two duplexes lots, so there can only be one on one lot and one on the other.
And let me add, too, that the duplex is being built on the left adjoining side of the next lot there. It's actually positioned 2 feet over from that side setback to give more space between the houses. So it would, in fact, it would be 10 feet between the 2 houses. Does that make sense?
Yeah, I guess I'm not sure what is 2.01 on your map and what is 2.99?
2.01 just shows the difference between the setback and the side of the proposed home. And then the 2.99 is how much footage is between the building and the lot line.
So one's to the eve, one's to the...
So in other words, one is moving over, but then the one next to it is also moving over.
Right.
Okay.
And I do have an exhibit on that if you'd like to see that.
You have an exhibit on the property that's to the left?
Yeah.
So the other side, that empty one to the left, it's already under construction?
Yes, it is.
Okay.
And we have a as-built foundation survey on that to show that it is, in fact, 2 feet over from the side setback.
The property to the left, that's XBC's on that property. So the new homes are being built 7 or 8 feet off that property line?
That's correct. 7.8 feet.
Why there's some notes about losing duplex eligibility if the lot line was moved. Why would that be? Maybe zoning staff can answer that, because it's zoned R.
So duplex eligibility under an R district is a use permitted with conditions, and it's not by right. So the lot needs to be in the same configuration as it was as of August 1 of 1984. If you shift those lot lines, you lose it.
I'm so glad you brought that up. I've always been wondering about that.
Anything else? Okay, very good. Close the public hearing. Discussion.
I think the council member has given it his blessing. It's a tough council district. To me, the unique situation is that you have two lots that are different in size. I'm very grateful that the one on the left is already under construction, because I would like to put a restriction because they had testified that it would be 10 feet from the under construction, that it indeed be 10 feet from that building. And with that, I'd say that I'll make a motion that we approve this variance on lot size and setback based on the shape of the lot and the horizontal property regimes that they're trying to accomplish, and that the restriction be that the setback will be the greater of 2 feet or 10 feet from the existing building. Is that right? So if the existing building is...
So if there's 10 feet between them.
There has to be 10 feet between the two buildings.
Okay. Motion. Yeah, they're good for that. Yeah. Motion's been made. Is there a second?
Second.
Okay, motion is made, properly seconded. Any more discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Passes unanimously. Last case.
With that case approved, we're up to 2017-130, involving the property at 207 Mildred Chute Lane, not too far from this very building, just going out 2nd Avenue South. Charles McTorry is the appellant. Charles Konowicki, the owner of the subject property. The request is for no fewer than 6 variances, itemized as follows. The appellant seeks variances from front setback requirements, rear setback requirements, side setback requirements. The appellant also requests variances from height restrictions, lot size restrictions, and the setback for the garage doors in this, the R6 zoning district, in order to construct a single-family residence. The zoning map here shows the subject property just off of 2nd Avenue South. The aerial, now dated, at least gives us a general sense of the layout as to the current development pattern along Mildred Chute Avenue. From a recent site visit, the property as it stands now, including the appropriate signage indicating the zoning appeal hearing, the view up and down Mildred Chute here on the left side, upper and lower, and then the view directly across the street in the lower right-hand corner. Is there anyone here in opposition to this case? Seeing no one, the opponent will have 10 minutes to make the desired presentation to the board. Please introduce yourself by name and address.
Good evening, ladies and gentlemen.
Yes, it is evening.
Charles McTorry, 600 Monte Carlo Drive. I want to build me a single-family home close to downtown.
So before you get started, you asked for 6 variances.
Small lot.
But still, that's a lot of different kind of variances to ask for.
Okay.
So A, what are the hardships besides a small lot? And can't you build a single-family house without asking for 6 variances?
Well, I guess I would say, I should say open to suggestions, I guess. I'm willing to change some of them if need be. I think when we had the house drawn up, we had it situated on a very small lot, centered, but
so yes, I mean,
even so,
you're asking for variance on the front, the rear, and the side setbacks, and then a variance in height, lot size, and then garage doors for this. That's 6. That's a lot. Because you understand, basically, we are the board that allows for variances because the code says this, and we, based on a hardship related to the physical part of the property, we will entertain them, but 6 is a lot to ask for.
Okay.
So any of our architects want to?
Yeah, I mean, I agree. I mean, I'm happy to hear you out, but it does seem excessive, especially, you want a 2,100 square foot house on a 2,300 square foot lot, and I know that some of those are going to be storied. It's a 2,300 square foot lot, and I know this board is reluctant to tell folks that they just simply don't have a buildable lot, that, we would try to make that work, but, you're at, and I don't know what the math is, but it seems like you're at barely 2/3 of the size that, is the minimum required to even build a home in the county, and yet you're going to build a 2,100 square foot house, which is a reasonably large house, and so.
With a garage.
Can I
So,
say
I mean,
something?
it seems like on the surface, it's just an awful lot to ask.
I just want to get clarification on this, but the 2,300 square foot lot is not a buildable lot in Metro Nashville, isn't it 3,750?
3,750.
So that in itself, I mean, is a pretty big variance. If it's a 2,400-foot lot and you're asking for a buildable lot variance. So did you just recently buy this lot?
Can I help him?
Sure, come on up. And identify yourself, your address.
Do you want to ask John Michael to pass these out?
And
sure.
What is your purpose?
My name is Josh Helmer. I'm about to live at 1071 2nd Avenue South.
Okay.
And Charles and I are friends. The site plan that John Michael is passing out right now, the side setback variances, I believe, should be taken care of because I think we have those at 6 feet, not at 5 feet. The garage door setback, that is because of the small lot. The front setback, again, because of the small lot, and the rear as well. The height variance, I'm a little confused by because I believe the house that Charles has had designed is only 31 feet tall.
So did you
Should be
recently
plenty low.
buy this piece of property?
Yes, sir.
And how much did you pay?
Well, you're under contract.
Well, yeah, it's under contract.
How
so
much
it's
did you
not-
pay for it?
110.
$110,000. Really? Oof. Did you know when you bought this that it was too small to build a house on?
Well, I knew we would be coming here.
Okay, that's fine. Yeah, I know, yeah.
Yeah, and I think one of the reasons that we thought that the lot was buildable was because there was a house at some point in time. There is sewer and water out there. And
there is?
Yes, sir. Yes, sir.
Okay.
So there was a small house that I was
So John Michael, what does that have to do with if there's proof of a former house on the exact same lot? I guess that's the caveat.
The zoning division reviews exactly that kind of question to determine whether or not a lot is actually buildable at all. Here, it can be buildable if, in fact, a lot size variance is granted by the Board of Zoning Appeals, at least with regard to the lot size question. But the analysis that the zoning administrator and the entire staff has to go through is kind of a historic determination of the parcel genealogy and any records we can find indicating has there ever been a house on that lot. And I know the zoning administrator's got even more particular detail he can add to that.
Okay.
Historically, myself and the prior zoning administrator, if we had a lot that was less than 3,750 and it had a house on it, we would allow, and it was in poor condition, we would allow the owner to demolish that house, come back and put another house in the same footprint or smaller. For us, the analysis is, was there a house on it that was going to be demolished? This case, there's not, but if he could demonstrate that there was a house there, that it is a buildable lot, he still needs the variances from the board. But
yeah. So, for example, there's something called the Sanborn insurance maps, which are actually online, and they were insurance companies that basically went around the city and did a plotting of houses by street, even materials used. And so I think there was one around 1915, one around 1900, one around 1887. And those are also very good places to see if a structure was there. But I guess the question is, once again, even with the side setbacks gone, that's still 4, and particularly the lot size variance. Does he need to do more homework, or what? Yeah.
Well, I don't want to get too far into discussion, but I mean, I kind of wonder, if there's property out there in this jurisdiction that doesn't meet the buildable standard size-wise, I mean, is that property supposed to remain undeveloped forever?
Well, no. I mean, that's why there's
that's why they're here.
That's why there's a BZA, and I guess.
So I guess what I'm saying is that doesn't bother me.
Yeah, the only, I guess, other problem is, he's under contract, and I imagine there's a closing date probably in the near future. So
I don't want to get into discussion, but that the size variance is fine, and in a way, there's a lot of tail. The tail is wagging the dog on this. The small property size is sort of.
Okay, so let's not get into this. So, do we have any other questions for the applicant? Or the friend, too?
Well,
do you have anything else? What else do you have to add?
The small lots, like he's talked about, so we have looked into that a few times, and I've turned down the purchase of some because there never were houses on them, so that kind of worried us. I did run into a property the other day at 505 and 507 Coffee in Germantown. It was like about a 3,000 square foot property that the gentleman was able to build 2 on because at one point in time there was a duplex there. So it does seem like some of the small properties are able to be developed, and I think Charles is willing to change what he needs to change. I helped him draw this up, and I felt like how we centered the house and the size we made the house with still allowing a garage for safety was about as minimum as we could do it.
The good news for you is there's no opposition.
Well, that's what I was going to say. That goes a long way.
You sat through the last case, and obviously.
And it's late in the day, and I'm feeling
no.
Hey, John, do we know what the height variance request is?
And I don't think there should have been one because I believe the house is only 31 feet tall.
Oh, really?
And I believe we're allowed 45 in the neighborhood.
Bill?
Is it? I'm sorry, I don't know if I have drawings in
We've
front
been
of me.
here all day, but how would we feel about entertaining the lot size variance, which maybe we don't have a big problem with, and letting them show us if they think they're good on the sides, and show us kind of where they are at that point.
Okay.
Is that? I know they've been waiting all day.
So do you understand?
But I sort of feel like
So basically, it sounds like this board is fine with lot size variances, and then you said that you probably need the side variances, but to kind of come back with some more information about the rest. Is that something that you all would entertain?
Sure, because I think we can fix is the minimum garage 10 feet?
5 feet, well, sometimes it's 5 feet from the property line, but our staff members.
I guess if we could have just 2 seconds from John to just know, I mean, what is the garage door variance and what is the height variance?
I know they don't have it. I just want to feel bad making them come back.
Because I believe we have.
I mean, I guess if we can, I guess to me, the ones that bug me are the height and the garage doors. The lot size doesn't. And even,
John Michael's back, so that's John Michael.
Do you know any of the detail on what the height and the garage door variance?
Yeah, why is there a height variance on this, and what is the standard for a garage door?
That would have been based on whatever was submitted to the zoning examiner when the original application was made. If there's updated information at this point, that's totally fine. We can go by that. It may be one of those things where if there is an updated site plan could be reviewed to determine if in fact some of these variances are not needed. Naturally, staff would be happy to assist them with that review.
So all right, so here on the code thing, it says for height, allowed maximum height is 35 feet, requested is 39.
Oh, that's where, okay, because it's 37 is the trigger, right?
So
garage doors facing alley.
Based on this lot size.
35 based on this lot size. So you asking for 39 is?
I think it's 37, which could be fixed with, instead of doing floor trusses, you could just do TGIs and lower the house 2 or 3 feet.
If we grant the lot size variance, they can go back to, if we were willing to discuss and grant a lot size variance, they could go back to staff to determine if they needed the other variances at all. And if whittle down what they may need and come back.
Yeah, and even if you still needed to come back, but it would
anything.
give you a little bit more comfort to maybe close on the property or feel like it's going to happen.
And I think if we eliminated some of the space for the rain garden on the east, we could move the garage door farther away from the alley.
Well, and you're a 2 foot, I mean, it's saying that the required 10-foot setback for the garage doors, and you're requesting 8. So you're close on some of these. So I
have an objection to it. Well, let's close the public. Do you have anything else
I have
to
one
add?
more question.
I don't think so.
Do you know
We're
the
just
neighbor?
willing to move things if we need to.
Do you know your neighbor, your closest neighbor that?
Yes.
maybe make sure they're okay with it. And
Yeah, I know him because I've spoke to most of the neighbors, and letting them know that I was going to move in.
Like I said, we don't have any letters
No,
of
the gentleman's name is
opposition.
James, and he's actually happy to see a new house in the backyard. The existing foundations are there right now, and there was a lot of trees, and he was happy to see some updating happening.
So the existing foundations exist?
Yeah, the existing foundation of the one picture that John Michael showed where he went out there. So that mound right there is still part of the existing foundations from the old house that's been torn down.
So there was an old house.
Yeah. I think it was torn down in 1978, from what I've looked up.
Okay. Any other things to add? We're going to close the public hearing. So, what do we decide? Motions? Discussion?
so if we make a motion on, or
I think I'm fine with lot size and garage door. It sounded like the height they could work out, and then the sides were not. They said they could work out too.
does that, I mean, I just don't want to leave them hanging where they have to like file another appeal. I mean, or are we appropriately leaving the door open for anything they can't fix that
They could come back
that we
here,
need to
yes.
revote on?
So basically just.
So yes, the board can take what amounts to being partial action on each individual
And then the
case.
rest
So we
they have to
vote
come
yes or no on these, we defer
We
these to a
defer the
later
rest.
date.
Yep.
Okay.
So they're asking for 2 feet of garage door, and they're asking for a lot size variance too. I don't have an objection to either one of those.
But then the front, rear, side, and height.
Well, they said the side that they could work with too.
They're going to try to fix all that and come back if anything they can fix.
I think we can put the east side at 5 feet, which is the
Open public
requirement.
hearing. We'll open it up. No, we'll open the public hearing.
As
You
long
put
as-
so you think you could work within the 5 foot for the
We can put
sides?
the east to the 5, and I believe that would put our garage door probably around 13, 14 feet, which should be a whole lot better.
Okay.
We were just trying to center the house on the lot to not impede on any of the
Gotcha.
neighbors.
Okay, we'll close the public hearing again. Any more discussion? A motion?
Can I make a motion that we grant the lot size variance and the garage door variance based on the hardships that we've discussed during this meeting, and that the remainder of the variances are deferred to only come back to us if necessary, if it's unable to be worked out with staff?
I'll second.
Okay, motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? It passes unanimously.
Thank you.
That concludes today's Board of Zoning Appeals meeting. We thank our volunteer board for their dutiful work.
Thank you.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.